aberration in ACR, my lord. Your lordship may kindly take up, even though it is 9.5 years have passed, but a union of India opposite party has not yet filed the counter affidavit. Lordship come to it, taken up a day after tomorrow.
Why are you making a mention after 9 years?
My lord, 7 years this tribunal, the judges were not there.
Now the judges are there.
Even if since this matter is not assigned to be for a specific bench, I have mentioned twice, but thereafter it could not be listed, my lord. Thereafter, the opposite party union of short time for filing counter. But even after 9 years, because since last November, the both judges are being available. So therefore, I am mentioning before lordship.
So no bench is there. No,
No,
assigned.
now this after November, this bench is functioning. After November 2023.
So you can go there.
Yes, my lord. I used to be a regular practitioner of the Armed Forces Tribunal.
So you can go there now. You can withdraw the writ application and file your application before the tribunal.
My lord, the matter is pending there itself. It is being stayed by this honorable court, my lord.
It has been stayed by.
My lord, since 2015.
So you are for?
I am for the petitioner, my lord.
So because of the order which you obtained,
My
the
lord.
matter is stayed.
My lord. That is against the order of Armed Forces Tribunal. That is interim order.
But at your instance, the proceedings have been stayed.
Yes, my lord.
Where? Proceedings of which
It is
court?
being stayed by this honorable court, my lord.
Proceedings pending in the
In the
tribunal have been stayed.
Armed Forces Tribunal, Calcutta. It is being stayed.
So what do you want?
That is the matter may be kindly be taken up because so far this opposite party has not yet filed counter affidavit to that effect.
So what order shall we be passing if your matter is taken up?
Let the matter be taken up and let the file their counter and I file the rejoinder.
They file counter affidavit if they have not filed.
So your lordship may take up then final dispose of the matter.
We are not, we have not been able to understand what you are saying. You filed a writ petition
Yes, my lord.
against an order passed by the tribunal.
Yes, my lord.
The matter is still pending before the tribunal.
Yes, my lord.
So you want the matter to be decided by the tribunal.
By here itself passed.
What
Passed because the matter is in state here.
It is stayed, but you must have challenged some order. What is that order you have
That is
challenged?
interim order 23/7/2014.
Forget about the date. What is the order? What
That
is
is
the
the-
order you have challenged?
That is that since there is a aberration in the SCR itself, because of which the promotion is being held up.
All right, we will see, give you a slip.
Milord,
May I take your lordship the day after tomorrow?
No,
day
sorry.
after.
Milord, writ appeal number 1742/2023. Your Lordship has reserved the judgment in writ appeal number 1742/2023, and judgment is here for pronouncement. In the meanwhile, OPT has also already started evicting the people and started erecting the high tension lines. So
All right.
we have already filed a miscase. Your Lordship can pass the order to no coercive action in the
No,
meanwhile.
no, we will dispose of your matter.
Milord.
Don't know. Well, since when the judgment is pending?
4/4/2024.
All right.
This is regarding restoration, but dismissed for default. IA has been
By
ACL
which bench?
this the PIL
DB?
matter. PIL matter.
DB PIL. PIL was filed when?
In 2015. It's
And
pending
when was it
counter,
dismissed?
rejoinder, everything has been filed.
When was the case dismissed?
21.
And when
Same.
did you file your restoration application?
1 day after, next day. Obliged.
My lordship,
List,
item number 27, it's a writ appeal. I am for opposite party. Kindly 2 weeks time be granted.
So you will have to seek consent from the appellant.
If I
Let the matter
reply-
be called. We will accommodate
Like,
you.
pardon to mention, my lord, item 17, my lord. May kindly be withdrawn.
I am there in the,
You are appellant.
I am the applicant.
So she is seeking adjournment. What do you want?
File-
In that case, you'll also may kindly see the noti.
Let the matter be called then.
Notice
Please
has
be
not
here
been
when.
File
Sufficient.
reply, to
Let it
file
reach-
reply time. be
Notice has
granted.
not been made
Oh,
sufficient.
please let the matter be called. We'll
My lord, item 17, my lord, may kindly be withdrawn, my lord.
withdraw.
17. All right.
This admission item number 2.
See that primary school matter. Yesterday they have sent me a copy, I have verified that. If that affidavit, your lordship would kindly see, given by the state. If affidavit again. That affidavit dated 25/6/2024. If your lordship is having a copy of that. Lordship-
Yes.
Lordship, you are having, kindly see this affidavit para 5. This is with regard to amenities, the format which I have given, with regard to availability of amenities in the schools throughout the state.
Annexure A,
Annexure B.
Annexure B.
First, I am taking your lordship to para 5. Your lordship may see that the format given by the learned amicus curiae in this honorable court is appropriate. For better appreciation, a copy of the format given by learned amicus curiae is Annexure B. Will you kindly see that Annexure B. Annexure B is not given the format given by me. They have diluted the format.
Diluted.
Yes. Kindly see my format, and they have said that this is a format given by me. In fact, it's diluted.
Where is your format?
My format is with my lords, my lord, I have given earlier.
No, is that on record?
Yes, lord, that's on record. But basing on that, your lordship has already passed orders. One more for my lord's assistance, my lord. I'm giving one copy, my lords may kindly accommodate. Kindly see my format. Lord, this is with reference to school, because amenities, whether available in specific school, more than 50,000 schools in the state, I am required to move to school wise to find out whether there is amenities or not. Therefore, that's the reason your lordship wanted that every information should be uploaded in the website of the department so that it is for public purpose, everybody can know with reference to the name of the school, district and block, name of the school. Now they have ignored this name of the school. In the third column, number of schools. How do we know whether in a specific school, whether these amenities are available or not? Then again, we'll have to move to those specific schools. It's as vague as it is.
Yes, my lord, I have seen that. Your lordship may see that column 2 and column 3.
No, no. Come to column 8.
Column
8.
8.
Yes.
Yes,
Read it.
my lord. Yes, my lord.
Read it. What is there?
Column 8, number of school with free access.
Now,
So whether
whether-
this information, what you have done, that you have replaced number with number in place of whether.
yes.
Yes, yes, my, yes, my, I have got. And also there is also I have found that your lordship may see column 2 also,
Yes.
that my learned senior has pointed out. This has been mentioned as district instead of school. Your lordship,
Name of the primary school, column 2.
your lordship got it.
Yes, yes.
That has been mentioned as district. So two discrepancies are in the format submitted by my learned senior and the format submitted by the school authorities. Your lordship may call this matter tomorrow. I will take instruction on the two.
Do it. Do it. This is not,
Yeah, I will take instruction on the 2
and
points.
this format is quite scientific.
And if your lordship permit,
Name of the district should be there. The district name of. A particular school.
Yes.
Particular school, like,
may I pray, my lord, your lordship may pass over it for, if that is the type, pass over it sometime, I'll take instruction in the
it will
meantime.
come tomorrow.
Yes, ma'am. If your lordship will permit me, I can instruct the secretary to appear online. She can apprise my lords also.
No, no, please do. You.
Yes, ma'am.
That is required.
Yes, ma'am.
Otherwise, is.
Yes, my lord.
The
my-
name of the
my-
district is not required to be mentioned.
my lord,
because Name of the district
My
shall
lord,
be at the top.
Secretary is online, my lord. Secretary is
Yes.
up.
Yes, madam.
Milord, really grateful for this opportunity. The format submitted by the learned amicus curiae is absolutely fine, sir. When we reported it back, I think there was a clerical mistake. However, we have absolutely no issue in mentioning the details of the amenities with the new name of the school. There is absolutely no problem, sir. It is
No,
acceptable.
no, the problem is that in place of number of schools, in place of whether, you have mentioned number in your format in Annexure B. So that is clerical mistake. Please do it.
Yes, sir, because we had, Milord, we had sent two, sir. I'm also keeping one. In fact, in both the cases, one we had sent back the same format which the learned amicus curiae has submitted, which is acceptable. And in fact, Milord, we would also like to have all these details with respect to each school, sir. We are also trying for that. We would be happy to get the information and furnish it, Milord.
Please do it.
We will do that. Yes, sir.
We are
And,
posting the matter. The matter is, shall be re-notified tomorrow. In the meanwhile, you can.
We will
introduce
submit the
necessary
corrected
corrections.
format. And Milord, we had suggested a small change in the annexure A that was submitted
Yes,
in order to get the information on the number of dropout children. In that,
Yes.
we had suggested a small change.
yes.
This change was required, Milord, to understand, let's say a child has not come to a particular school. That need not necessarily mean that the child is dropped out.
Dropout, right.
It could be because of various reasons. To incorporate those reasons, we
Right.
have suggested a small change in the format and we've also submitted that.
No issue.
Can I have a little submission on that? Subscriber permits me, Milord. I have prepared that chart keeping in view to the provisions on section 3 and 4 of the Act. It's a central act. Now, admission into the school in the age group of 6 to 14 is compulsory. And finding out dropout from the school is also compulsory. They will have to find out. So to find out that whether exact number of children who have taken admission, not taken admission, we'll have to find out that may take time for that
This is
also.
what she is saying.
In fact, what they're trying, my learned secretary is saying is that availability of children, what is the exact number of children in the state who are admitted, who are not admitted, unless we have a database, we cannot come out with a figure that this is the extent of children not admitted. We'll have to have a database. For that, it will take.
No, what she is saying, that suppose 20 students are admitted in a
Correct, my
school,
lord.
in a class,
Right.
say class 1.
Right.
And in class 2, there are only 10 students.
Right, my lord.
So we should not presume that there are 10 dropouts.
Not at all.
They might have shifted to a different
Yes, that's
school.
correct. Very
They
correct.
might have shifted to a
I
different
agree.
place. So therefore, what she is saying that, see, the department will be inquiring about the reasons why.
With regard to dropout,
Yes.
but non-admission, left out students who have never taken admission. How do we know that?
That is very difficult.
Very difficult. That requires a complete database, a census like work.
That is very difficult.
Yes, my lord. That
See,
requires.
in fact, I was going to suggest that someone should take up this cause, that there are, the slums. When I come from my residence to High Court,
Yes.
I notice there are some slum dwellers.
Yes.
So whether any, not only the government, yes, government has a duty to do,
Duty.
but every citizen has a duty,
Duty
has
to
also
that.
a
So
duty
To that, what I'm.
to make a survey as to whether those
Exactly.
children
Exactly.
go to a school or not.
We have Anganwadi
all of
workers.
us, all of us, in fact, if required, I can involve the legal services authority also.
That in fact, I am
for-
trying to
for
requesting
this
my
purpose.
learned secretary, but this is not an adversarial litigation.
Right.
But we are trying to improve the primary school education and this fundamental right of children we are trying to protect. Now, what is the exact number of children, 6 to 14, and whether they have taken admission or not, unless that census type exercise is taken up, it can't come to the.
We can do that.
Right.
We can do that. Let us
That's a
begin
bigger
from
exercise.
Where, yes, madam. you want to say?
Lord, if I may submit before your honorable court, that you are absolutely correct, sir, that we have a number of urban habitations with floating population where we see that children are not attending school. This has been a matter of concern for the department as well. Recently, we have had a meeting and a discussion and a decision for involving civil society organization for identifying all the urban habitations in which floating population and therefore children not attending schools are working. We have made a list. We've also had one meeting with all these civil society organizations. We have also finalized a format for surveying of children in such localities. We will be having subsequent meetings with them. My lord, I'll be very happy to share all the findings that we will be having from that survey.
Please do that.
We can take up a pilot project. Then we can expand it to phase-wise different areas of the state. So we must endeavor to do that. That's all my endeavor is.
Let's this matter. We notice apparent clerical errors in Annexure B to the additional affidavit which has been filed by the Commissioner cum Secretary. Which department is this?
School and mass education.
School and mass education.
And Mass Education Department, Government of Odisha. So stop this matter tomorrow. So as to enable the state to file another affidavit with correct format.
Yes.
Mr. Rath, your format, would it be better if that column 2 name of the primary school goes on top?
Yes.
Because this is
At the top, as your lordship.
no. Just think about it, because this is, I think, as per the school.
Yes.
So why should the name be here? It can be here. A particular school.
This whole format is for one school.
One
This is
school.
for one school.
We have data.
Comes here, will it help? Separate schools, separate tables. No, all this will be there.
Primary school can be mentioned at the top.
Yeah, that can be done.
No, because there'll be
I
for
think
separate.
it solves
schools,
the
the table.
purpose. Yes, yes.
Madam, please.
Yes.
Sir, the information, my lord, will be collected in the form of an Excel format in which any number of reports will be possible. If required, we will be able
Right.
to get the report school-wise
Very good.
or facility-wise.
All right.
That's
Very good, very
All
good.
right.
That's all. Now, this bigger issue be deferred for some time. No issues there. This bigger issue of dropout and admission be deferred for some time. Let this amenity part be solved. Then bigger issue will be
No,
taken.
we will take up.
Raju.
We will take up.
Ajay.
Yes, madam.
My lord, we are willing to do it simultaneously because these two things because for the dropout issue in the urban habitations, since we are also involving the civil society organizations,
We
both
will
can
take up,
happen
we will take up
simultaneously.
that aspect, madam, tomorrow.
Yes.
We
Right.
may pass certain orders tomorrow. In fact, I would like to involve the Legal Services Authority also in such matters.
Yes.
We have paralegal volunteers, we have, so they can also go to the places to find out whether the children are going to schools or not. So that can be done. And these are the children who should be admitted in those schools, private schools. You Yes.
Absolutely right. Yes, sir. In fact, we would also be looking at a number of amendments in that regard, sir. Because at the present, as per the present norm, sir, even there could be capturing by elites, sir, of the seats that are currently available. We would also be looking at amendments in that regard, sir. You're absolutely correct, sir.
Tomorrow.
Grateful.
Grateful for the opportunity, my lord.
Item number 3.
May I please, my lord?
Item 3, my lord, yesterday I have filed the affidavit, but that is not your lordship's board. The noting is that is not your lordship's board. In
Yes, sir.
both ways I have filed, the hard copy filed and also by filing through e-filing.
He said he will file, so it's supposed to get it.
Have you filed the hard copy also?
Yes,
But the children are attending classes.
Yes, my lord. As
The
per
students are
Yes, my lord.
attending
But
classes.
so far as the present petitioner is concerned, my lord, she has been allowed to attend the classes. In the affidavit, my lord, they have stated that who were not there before your lordship. They have said that simultaneously they'll be also sending them because they stand in a different footing. But my lord, I am there only on the quantum of the punishment which has been imposed.
We will see that.
Yes, my lord.
We will
Your
see.
lordship may kindly see the affidavit. How they have tried to
Your
improvise the
lordship,
case.
one
A,
paragraph of my affidavit from the day one.
See, mister, we don't want to record any finding
Yes,
on
ma'am.
that. We want that the vice chancellor, as the guardian of all children, should take some decision.
Well,
Should be,
So in that
my lord, each
respect, your
time,
lordship may direct the petitioner to approach, to appeal
they
before
will
the.
approach, let the affidavit come first,
let it come.
they will approach.
And
And there is
in my affidavit, there is nothing stated in merits of the case. Only your lordship day one, your lordship
I
observed.
want that to be incorporated in our order. Therefore, we
Yes.
want that affidavit order. It is stated by learned counsel for the university, which is
University, my lord.
for the university, that an additional affidavit,
A reply affidavit.
that reply affidavit has been filed online yesterday.
Yesterday,
Physically also, only online.
Physical copy
both
of
ways.
the additional affidavit, of the said affidavit has also been filed. Full stop. None of the pleadings, neither the additional affidavit is not available either. Either the soft copy or the hard copy of the said affidavit is not there on record. List this matter on Monday. Ensure that.
Item number 4.
Person item number 4, lordships wanted me to file that affidavit incorporating the development that has taken place because my learned friend had doubts regarding the steps taken by us lords. My affidavit is going on, lordship can take it up at 2 o'clock so that I can file affidavit. Now the final gradation list has been published. Vacancy position has also been intimated to the concerned district collectors and they've been directed to implement the order of lordship and give promotion, lords. This is that I will not say 2 o'clock will also file that affidavit. This is the final gradation list, includes the name of the present petitioners district wise. I will also take it up at 2 o'clock. I have no objection. I'm getting it ready.
So order has been complied with.
Well, have to receive a copy and take
Give
it.
him.
No, he can give. My friend can give the promotional list and the vacancy position also.
2 o'clock, they are going to file the affidavit. Let him serve a copy and I will take a instruction in that matter and your lordship may kindly call it on 8. I will receive the affidavit from them at 2 o'clock. Your lordship may allow me just one last chance to obtain instruction. Your lordship may call it on 8.
What was the order? Let us see.
Alert. Page 37, my lord. Page 37, your lordship and kindness. Having regard to the statement made by Mr. Kuntia, we direct the Labour Commissioner to upgrade the gradation list following the procedure within a period of 4 months from the date when the petitioner will produce a copy of this order. It is needless to say that if the vacancies are available, the zone of consideration shall be created on the basis of the gradation and the persons in the zone of consideration shall be considered for promotion in accordance with the prevailing rules with expedition.
All right, we may adjourn it for 8th. But in the meanwhile, everything should be done.
No, everything, as per the direction, everything has been done, Lord.
No, you have not done this consideration zone, and persons in the zone of consideration shall be considered for promotion,
Yes, Lord. Vacancy position has been intimated.
right?
District-wise gradation list has been published.
Very
Now
good.
only promotion shall be given.
That is not only, that is the thing.
Yes, Lord. That will do, Lord, because this.
That will have to do.
Yes.
Land Council, Land AGA appearing on behalf of the contemners has submitted that in the light of this court's order dated 29/8/2023, a gradation list, final gradation list has been prepared and in
Vacancy position has been intimated, Lord, may also say.
and vacancy position has also been intimated to the concerned
Collectors and district magistrates, Lord.
collectors and district magistrates. Stop. List this case on 8/7/2024. Stop. If by the said date, the contemners fail to comply with the court's order by considering the cases of promotion in accordance with the prevailing rules, all of them shall be required to be personally present in court for this court to consider framing of charge of contempt of court against them.
Yes, one submission, Lord. We'll start the process of, Lord, constituting DPC and giving promotion. Because why I say, Lord, why I say, for promotion, CCR is required, vigilance clearance is required, so it may take time, Lord. Within 7 days, we can get all these things. They will be considered, Lord. All those persons will be
We
considered.
we don't know how will you move. If you want, we can convict them tomorrow.
No, that I understand.
Because the order has been violated and despite opportunities granted, the order has not been implemented.
Right, Lord.
So if we this is like an indulgence which has been granted.
No, that I
to-
about on, Lord.
Otherwise we can just you have violated the order and you don't have any explanation at all.
Lordship, look at the order. Lordship said that promotion, the DPC's the process for promotion shall be considered, and persons within that zone of consideration shall be considered. Lord. We'll consider all, Lord, because now it is
So
district-wise.
you may consider after 5 years.
No, Lord, that is a maximum of 15 days, because Lord, vigilance clearance shall be
So
obtained.
15 days we are giving.
Uh,
How,
8, it may not be possible, Lord.
all right, 15th.
Good.
15th of July.
5 years CCR records are also be called for. So DPC will immediately
Therefore,
do it. Lord.
15th of July.
Yes, sir. Okay.
Whatever affidavit they are filing, let them
No,
submit.
I will give a copy, Lord, sir. I will give a copy.
Test admission item number 5.
Was listed yesterday. Your delay already condoned, and your lordship had issued notice. My learned friend has entered appearance. Here the issue is.
Kindly take it up next week.
Next week,
my.
as requested on behalf of the respondent, this matter on next week, next Wednesday.
Item number 6.
May I please? Here, my lord, on the last occasion, your lordship directed to impede Director Ames, All India Institute of Medical Science to as a party, my lord. And I am filing for application for impletion.
So violation of the order dated 14/3/2023.
2023, my.
Which order, which part has been?
My lord, here, my lord, my lord, para 3, your lordship may kindly see. In view of the above, this court disposes of this writ petition, directing the opposite party number 2 collector to act upon the later dated 9th March 2023 issued by the senior administrative officer and lady in charge Ames Bhubaneswar to make assessment of the compensation amount so that the benefit can be extended to the petitioner as expeditiously as possible, preferably within a period of 3 months from the date of production of the certified copy of this order, my lord. But thereafter, my lord, he is not providing the amount required to be deposited by the Ames, despite the request by the Ames to provide the same, my lord. The contemptor has failed to discharge his part of the. If your lordship will looks at, my lord, I am passing on a letter given to by the, my lord,
What is this?
for impletion of party.
For what of party?
My lord, on the last occasion, your lordship directed that Ames should be made as a party in this case.
Why?
Because he has alleged, the collector has alleged that the Ames has not submitted the proposal. But the fact remains, Ames has submitted the proposal. Your lordship, in the order dated 14th March, this honorable court has specifically directed that on the basis of the letter dated 9th March 2023, given by the Ames to the collector for the purchase of the land of the petitioner, he has to give assessment. And on the basis of that letter, the collector has to submit the assessment and Ames will deposit the amount with the collector for disbursement in my favor. But it has not been done, my lord.
No, but why should the registrar or what have you said, executive director Ames be made a party? There's no direction to the.
Yeah, my lord, on the last occasion directed that director Ames to be added as a party.
In fact, has not been acquired. Your land has not been acquired.
No, my lord. They have already, my lord, that has not been acquired.
Acquired under the Act.
My lord.
Your land has not been acquired under the Act.
My lord. They wanted to purchase it. The direction was to not to acquire because they have already acquired it and enclosed it within their boundary. So therefore, they want to purchase it. So for that reason, collector was to submit because it was earlier leased out by the government in my favor. So therefore, what is the market value of the property is to be intimated to the Ames for deposit with the collector for disbursement in my favor. That has not been done.
No, because the order is that collector is to act upon the letter dated so issued by the senior administrative officer and DT Ames Bhubaneswar.
My lord.
The direction is to the collector.
Yes, madam. Direction is to.
They are denying.
Last occasion, lordship wanted me to say the role of the collector. In fact, in response to lordship's order, collector had directed the authorities of the Ames to give some documented details, my lord, so that on the basis of which the market price shall be fixed, so that it can be intimated, my lord. So the Ames authority did not, my lord, submit the documents as required by the collector. That is my letter. That is why lordship wanted the Ames authority to be implicated as a party, not that the collector has deliberately violated lordship's order, my lord.
This is the subsequent development. The collector wants the documents, but the documents have not been supplied.
But my information is that they have provided the document.
Then don't implement the party. You file that affidavit that they have submitted. If you have the personal knowledge, you have got that. I don't know what is this. Lordship wanted them to be implemented party. Now he's saying that they have submitted.
No, I have filed application for impletion.
No, as the collector submitted, why he has not complied with that order?
Yes, Lord. This information, Lordship, last occasion saw the end, Lordship passed this order. If Lordship says also, I can file an affidavit by the collector also, Lordship. This is letter dated 14/5/2024, Lord.
So what is the area?
200 decimal.
Since all the office functionaries are preoccupied by simultaneous general election, 2 months more time is required for compliance of the order of the Honorable High Court. That is there in the letter.
Simultaneously, Lord. But prior to that, Lord, you see, in order to comply with the Honorable Court direction, and in response to the letter submitted by the senior administrator such and such, my lords, Bhubaneswar, the land acquisition officer requested senior administrator officer aims
By
to
which-
submit the requisite documents needed for fixation of market value and calculation of the height this due to non-submission of the requisite documents by the aims.
We will not see something which is not there on record.
My lord.
Now, last but one paragraph, due to non-submission of requisite documents by aims, there is a delay in ensuring compliance of lordship's order. This is the letter of the collector. My lord.
No, but how the land was utilized by anyone?
But it's a government land leased out in his favor, my lords, for long-term lease. Subsequently, I think AIMS has acquired the land for construction, and this land must be within that area so that they have occupied it without, I don't, because it is government land, there may not be any notification under section 4(1). But he has to be paid the compensation because his land, even if it's a leased land, my lords, he has got a right to be compensated, my lords. So that is why lordship directed that it should be through, my lords, direct purchase scheme, because for one particular land, there may not be a 4(1) notification. So he has to be paid that amount, there is no doubt, my lord.
Petitioner has arranged in disobedience of court's order dated 14/3/2023, passed in WPC number 4656 of 2015. Paragraphs 3 and 4 of which read as under. So, it is alleged that despite this court's orders, the amount of compensation payable to the petitioner has not been determined. So, a stand has been taken on behalf of the collector Khurda that the director aims Bhubaneswar has not responded to the communication made by him for the purpose of assessment of the amount of compensation. Though communication dated
But so. 15/5/2023.
Huh?
15/5/2023.
15/5/2023. Full stop. Next, IA number so and so has been filed seeking number has not been given.
My lord, I have filed here.
How can we take this? Why did you not file in the?
I'm filing in the registry today, man.
We could have called for the.
Don't know. How could you file?
Sorry,
this?
my lord, I will file it in the registry today.
How could you do that?
No, my lord, I
We
have
want
filed
to
here,
know.
my lord, I am saying that
Okay. Based on oral submission made on behalf of the petitioner as noted above, let Executive Director aims Bhubaneswar be pleaded as opposite party number
2.
So on appears.
No.
Mr. Sanjeev Swai has appeared in the writ application on
Issue
behalf of the
notice.
AIMS.
Issue notice opposite party number 2.
In course of the day, consolidated cost title I am filing.
Do whatever.
Item number 7.
On the set of writ appeals, the appellate is the Odisha Water Supply Storage Board, and the interim orders passed by the Honorable Single Judge is regarding the regularization of service of DLRs. In a similar case, in fact, last week we also class
Regularization of,
DLRs. DLRs.
what is the
District labor return.
district?
Labor return, DLR.
Fourth grade employee.
Class 3, class 4 employee. They were daily wage basis. So daily wage. They're basically the daily wage only.
Yes, what is the order of the
Court
court?
can find it at Annex 1 at page 35. The similar writ appeals were filed by the appellant court and it was listed last week. This was the order you also was
All right, go ahead. If you notice, come on. Back. All the connected. Copy of the rate appeals will be given. We are applying for the caveat, my lord. Copy of the rate appeal will can obtain.
My lord, I am also, my name doesn't appear. I have already filed Waklatnama. In items, last item, my lord. Item 7, last, my lord.
WA 857,
Yes, my lord.
Salja Nandan Das.
Yes, my lord.
I am the appellant. Now I'll serve a copy.
Vijay Kumar Sambal.
That will be served on. Have you filed your?
I have filed on Waklatnama.
All right. Name will appear.
Which you are appearing in which case?
My lord, rate appeal 852/2024.
852.
852, my lord.
Yes. One and
There are other 4 writ appeals. I'm giving the number same out of one order.
Well, I have filed the memo. There are total 34 writ appeals filed by the appellant court and 16 writ appeals have been listed. I have given the memo. It will be listed during this week or next week.
WA number?
I am appearing W.
So many cases,
846.
those cases, no, it is. In cases where the parties have.
copy can be served. So which?
And no, this is required to be issued in their cases. So who are, in which of the cases the parties are appearing, the other side is appearing?
Madam, which is your case?
846.
846.
WN.
Please, name please.
Sangram Mr. Advocate, I am Biren Kumar Singh.
All right. So Mr. Sangram Kumar Mishra,
Sangram.
only Sangram Mishra.
Sangram.
Sangram Mishra and associates. All right. You have filed Waklatnama or you will file?
Yes, my lord. And the course of the day.
You file that in the registry.
But I blame not a short date may be fixed because these people are serving for last 25, 26 years.
One moment.
There are many people who are not serving anywhere.
Absolutely, absolutely right. Absolutely right.
So, but like, there are a number of cases that is like
34
similar
number
matter.
of cases are
This
there.
has to go to the.
Already juniors have been appointed. As they have gone to Supreme Court has confirmed. Writ appeal was dismissed. They went to Supreme Court confirmed. Thereafter, they have already given them the regularized juniors. So we are now standing in the.
Yes. The Supreme Court judgment is there, then what case do you have?
What has happened? There are total 80. There were total 80 number of DLRs. 2 people came in the year 2006, and their writs were allowed in 2019. And the board preferred writ appeal, which was dismissed, and subsequently the board also preferred SLP, which also was dismissed. Now, once those 2 writ appeals were allowed, the writ petitions were allowed and SLPs got dismissed, then all rest 74 persons they approached the Honorable High Court and got the same order. Now, the problem is the board doesn't have the sanction post right now. And
All right. If you notice, and late announcer who is appearing.
Thirty-one numbers they दिया सुविधा का
We served upon them. Served copies.
I'll serve in the course of the day to all.
In court. So in how many cases you are appearing? The respondent, in one case you are appearing.
One case,
So you must have served a copy.
no, they have not solved.
You should have served. He is a caveator.
Well, caveat was solved.
Caveat was Caveat was filed, then it is noted.
The caveat numbers have not come. That hasn't filed,
I have-
but that has not come.
When did you file the caveat? After filing of the writ appeal?
No, my lord, on 2/5, before filing.
Okay, somehow it has not been tagged.
It has not been listed yet.
So therefore, you were required to serve a copy. Caveat application was filed on you.
Notice.
So you are required to serve a copy before filing. That is the requirement.
I filed the writ appeals.
Oh,
No, I filed the writ appeals before they filed the.
oh, all right. All right, now he accepts.
The interim order, Lord, I have also filed an IA.
The file,
Yes, needs writ appeals, I filed.
all right, straight. Okay, no.
Item number 8.
होगा सब ठीक
Make visuals. In that matter, where the Raulkela Development Authority wanted no objection from the wife of the original lessee after his death, that was renewed. That lease was renewed in favor of the wife, widow. Now, widow wanted under the influence of some third persons to sell away that property. So the others objected. So the Raulkela Development Authority wanted no objection from other legal heirs of the original lessee. That was impugned before this honorable court. The honorable single judge, the findings are at page 24, running page 24 of the appeal.
Yes.
There, his lordship held that no objection is not required since it was exclusively in favor of the widow. Your lordship the other day, since it is a family dispute like, wanted to have a family settlement and directed accordingly. In fact, I wanted to meet my mother, but I was prevented by that person who is keeping her with him. So that having been the problem, there has been no outcome as per your lordship's directions. So we are not against any settlement. If it is settled, it is well and good. That your lordship wanted also.
Yes, we will decide it then.
The statement that is given is not correct because after that letter, initially an English
No,
letter.
we don't know. We may be incorrect, you may be correct, we don't know. There is a list before us that has to be decided, we will decide.
And that is right. The Lordship will decide
Unnecessary.
this. Madam.
This thing. It was because of the dispute in the family, we wanted to get that resolved.
Yes.
We will decide as per law. Yes, make your submission.
So I rely upon 3 citations of the Honorable Supreme
No,
Court.
let us, you address on facts first.
Let me furnish a date chart that will be of assistance to your lordship.
Should have furnished.
Some other day, tomorrow or day after.
As requested on behalf of the right? This matter on 2 weeks.
You must have filed a date chart with the writ appeal. Now it won't be listed without a date chart. Please check.
But
Now-
those
now that
chats
is-
are little.
Yes, date chart is there, but you give it one date just to get over the defect.
I'm sorry, I should have filed.
Ma'am, only.
Staff reporter should be asked, what is this? Have you seen the date chart? One date.
Ma'am, I'm praying the citations of respective parties be exchanged so that there can be better assistance.
That
to
is
your
up to
lordship.
you.
Ma'am.
Citations are, he may withhold the citations which he is going to rely on. So that depends on your equation.
Madam, why I'm praying there will be better assistance to your lordship, madam, if it is extended before.
We will see.
I'll do that, madam, my and senior may also do that.
So matter could not be settled. Now you are not agreeable to
settled
exchange the
ସେ
citation.
ଯାଇନାହାନ୍ତି ମୁଁ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଗ ଇଂଲିଶ ଚିଠି ଲେଖିଲେ ମାଙ୍କୁ ତାପରେ ଇଂଲିଶରେ ଯେତେବେଳେ ମୁଁ ଏଠି କହିଲି ଅନରେବୁଲ କୋର୍ଟକୁ ତାପରେ ଗୋଟେ ଏବେ ଓଡିଆରେ ଚିଠି
Why
ଲେଖିଲେ
you use Korea?
that is because your lordship Madam, in fact, initially he wrote a letter in English to the mother. When I pointed out to the bench presided over by my lord the Chief Justice, now he has become wise, he has sent a Odia letter. I have taken instruction, he has never visited the spot. And I have given instruction that if he visits the spot, he should be allowed. That's my standing instruction to the client. There can't be any prevention for a son to meet the mother. I can't be, because I am defending, I cannot be, my lord, instructing that way. That's not the way.
All right.
My,
Item 9.
Problem. Your lordship fixed it today up to
2 weeks.
problem.
Sir, I am present
Interim
for-
order is there if your lordship please.
Shall
I'm-
continue.
I am present for expert number 5 development authority. I am present for expert number 5 development authority.
Yes, remain present.
Item 9.
Here the appellant have filed this appeal against the order of the Honorable Single Judge, who have refused to grant compensation for the death of their earning son at the age of 32 years, who was working as a junior manager, mechanical.
Where is the order?
My lord,
Yes.
wait a minute. Who directed to approach concerned authority, my lord, under section 10A of the EC Act, which is not applicable to me. Because here he was not a workman, but working as a junior manager. The Employees Compensation Act defines employees at his definition that as per provision under section 2 of the EC Act, employees means a person employed in such capacity otherwise than the clerical capacity. Here I am a junior manager working engineer, mechanical engineer.
What's the meaning of otherwise than clerical capacity?
That Odisha,
No, what is the meaning of otherwise than clerical capacity?
that bumper, electricians, all those are coming under. That is defined in this notification.
What is this Bhusan Steel?
Bhusan Steel at Dhenkanal, he was working as a junior engineer.
It's a private company or a government company?
Private.
Government, Tata Steel,
Tata Steel is government.
yes.
Tata Steel is government
Not government, that is undertaking,
undertaking.
yes.
The writ petition was not meant.
Private, yes.
Private party.
How can you maintain this writ petition? How could you maintain? And some order has been some your.
My lord, just like cinema, Upahar Cinema Hall, that is a private, that is also maintainable here. Regarding maintainability,
All right. And
Upahar tragedy.
and why 1 crore? Why not 50 lakh?
My lord,
You are seeking compensation to the tune of 1 crore.
yes, ma'am.
Why not 2 crores?
That is up to lordships to decide.
Or Lordship will dream something or imagine or what?
No, he was working and he was getting salary to the tune and he was.
That how will that amount be determined? And therefore, let single judge.
Yes, that has to be determined as per the Motor Vehicle Act, my lord.
Sorry, the present intra-court appeal has been preferred against an order dated 22/4/2024, passed by a London single judge of this court in WPC number 3077 of 2014. Full stop. How are you related to the deceased?
Father and mother.
The son of the petitioners was employed under Bhusan Steel Limited and others, and is said to have died in an unforeseen accidental fire in the said steel plant at Narendrapur, Dhenkanal. So, the petitioner filed the writ application seeking direction from this court with application under Article 226 of the Constitution, seeking a direction to the Bhushan Steel Limited and others, comma, is to pay compensation to the tune of rupees 1 crore along with interest of 12% from the date of incident, that is 12/1/2013. So next, it is not in dispute that the that said Bhushan Steel Limited is a private company. Private company and not stayed within the meaning of Article 12 of the Constitution of India. Next, one single judge has noted in his impugned order dated 22/4/2024 that the petitioner could invoke the Employees Compensation Act 1923, Section 10 whereof prescribes the mode of compensation to be paid to the employees who either suffer from injury or die. Where employees who either suffer from injury, mode of compensation in case of death of an employee or injury suffered by an employee while working in factory establishment. One single judge, comma, in the court's opinion, has rightly noted that there being a factual dispute on the there are two reasons why this court is not inclined to interfere with the order passed by the learned single judge. Firstly, comma, the writ petition in the facts and circumstances of the case was not maintainable against a person, against company, comma, not stayed within the meaning of Article 12 of the Constitution of India. Secondly, comma, the amount of compensation was to be consequent upon the death of the employee and the accidental fire was required to be determined, is required to be determined in accordance with the statutory prescription. By prescription by a competent authority.
When should you have filed the claim?
Yes,
This case is not maintainable under the Employees Compensation Act. I am placing this. Because he is a workman. I am a managerial capacity.
So that is your contention is not maintainable.
Yes.
So that is why the order of the learned single judge is wrong.
Yes. It has to be
Then you go
decided in
before
a writ jurisdiction. And
Yes.
your lordship has opined that it is a private institution. But most of the private institutions are decided in Article 226 and 32 of the.
So
There are so many decisions are there.
Go before the court which have decided. When counsel for the petitioner has submitted that Employees Compensation Act 1923 is not applicable in the case of the petitioner appellant who was working as
Junior manager.
And therefore not an employee within the meaning of Employees Compensation Act 1923. Be that as it may, comma, in a proceeding under Article 226 of the Constitution of India, the court cannot go into the question of amount of compensation payable to the petitioner by a private employer. Stop. A private employer who, tell again? Computation. Able to the applicant. Applicant consequent upon the death of his son, death of their son in the steel plant in an accidental fire. So stop. The petitioner shall, however, appellant shall, however, be at liberty to approach appropriate forum in accordance with law if they intend to claim compensation.
For Senma, Mr. Nandi, they were not employees, they were the members of the public.
Your lordship has decided I have no objection, but here my conscience
You
says that
cannot
it is
have any
not applicable.
objection. You have liberty. You can challenge this order.
Yes, my lord, that I know. That
That you can.
so many decisions of the Supreme Court's apex court, my lord, it is maintainable. Your lordship has decided it is not maintainable. Then I have nothing to say.
Mr. Nandi, why are you getting so agitated? You have not
No, no,
brought,
your
you have not
lordship has
brought
decided,
those, Mr.
then I have
Nandi,
nothing to say.
you have
sir.
not brought those decisions.
Regarding
to the-
maintainability, then
Please,
you have
please.
given a chance, then I
Please.
put for
You have not brought those decisions to the notice of the learned single judge also. Have
See,
you?
Single judge has not asked, he has stated that that is factual disputes. What is the factual dispute? It has been decided by the everything. The company has given me that death certificate.
All right. Good.
Yes,
Item number 10.
urgent copy.
No. Urgent copy, you apply online, you will get it.
Yes,
Get that.
that way your lordship.
No, order is not
requirement.
necessary. You are getting it in time.
Yes.
May I please, Lordship? Lordships, Adivasi people before my lords seeking protection under Forest Rights Act against illegal eviction and demolition of their houses. They assail the illegal and unauthorized realignment of BDA road into a forested region coming under the Gram Panchayat area in violation of the Odisha Development Authority Act 1982 and rules framed thereunder.
What is this matter about this PIL?
PIM lots.
What do you want?
I want the realignment, unauthorized realignment, which tinkers with the modified plan of BDA by engineering works department is to be set aside because it is against the mandate of the Development Authorities Act. They cannot tinker with the modified plan and they cannot even transgress into a Gram Panchayat forested area where the Adivasi people are living since 3 generations, my lords. Under Annexure 1, lordship, it's a modified master plan which is notified in the Gazette. Annex 1, my lords. After consultation, invitation of objections, and hearing the stakeholders and affected parties, the modified plan has been notified in Gazette of Odisha under Annex 1 since 2018.
File your affidavit.
Yes, Your Lordship, give me 2 weeks time.
2 weeks time is allowed for the.
Lordship, status quo I pray because they are involved in illegal construction and also the main trajectory which is notified that is being encroached by land grabbers, which will prejudice the lordship status quo. Status.
No, not now. After 2 weeks. Yes.
Item 11.
Please allow for the state to file a counter affidavit.
Item 11, they were
Yes, yes,
state was directed to file.
Yes, Your Lordship, we've received the PWC. I need a week's time to file.
1 week for the time is allowed for the state to file counter affidavit. Next case.
Item 12.
May I please, Your Lordship? Your Lordship, in this writ petition, the order dated 15/3/2024 passed by the revenue authorities has been challenged, wherein, Your Lordship, the fact of the case is that there was an auction for the sand quarry and the petitioner was the highest bidder. Thereafter, due to some physical illness, Your Lordship, the petitioner could not give his willingness to execute the lease agreement. And thereafter, he communicated that he could not participate further. Thereafter, Your Lordship, the Tahsildar, as Your Lordship may kindly see in page 21, Your Lordship.
Yes.
The Tahsildar communicated the same to the collector and said that since the second highest bidder had quoted unusually low, therefore he sought instruction to proceed further with the auction, Your Lordship. Thereafter, no action was taken, and almost after 2 years, another order was passed by the collector stating that the quarry may be settled in the name of the second highest bidder. However, in the meantime, Your Lordship, the petitioner has already communicated that the petitioner wants to withdraw his unwillingness, and since he was the highest bidder, the petitioner is now willing and willing to go execute the lease deed, Your Lordship. And since the second highest bidder was unusually low, it is very much in the capacity of the revenue authorities to at least consider the willingness of the petitioner, Your Lordship. Hence, the petitioner has communicated a representation which has not been considered by the revenue authorities till date, Your Lordship.
My lord, I have received the instructions in the shape of para-wise comments. So also a document where his representation has been considered and rejected by the Tahsildar Jharban on 22/4/2024. And there in the rejection order has categorically stated that the unwillingness submitted by the petitioner was not on the basis of health ground. He has simply submitted his unwillingness and subsequently he approached the Tahsildar that you allow me query, and accordingly it has been rejected. So this gives rise to a fresh cause of action if she is.
No fresh cause of action. You expressed unwillingness. You cannot file, you cannot maintain this.
That too after how many years?
And
After-
where have you stated that on hill grounds you had
Your Lordship, it was not
paragraph
stated.
10?
No, it was not stated in the communication.
But
The ground
then-
was not.
Paragraph 10 you have stated.
Yes, Your Lordship. I've made an amendment in this writ petition, Your Lordship. It was not communicated to the
An
authority.
afterthought, madam.
But Your Lordship, had the agreement settled at
Don't-
that time, Your Lordship, it would have been a different case. But since 2
Don't
years,
write any observation from this court.
Your Lordship may then,
We are not happy.
Your Lordship may grant liberty to the petitioner, Your Lordship,
No representation.
Liberty for what?
to challenge the reply, Your Lordship.
It's been rightly rejected. So the government has sustained loss because you denied and that thing could not be settled. And because of you, government has sustained loss. So why should any liberty be granted to you?
Well, the agreement has also been executed for the opposite party number 6 on behalf of Mr. Tapavanta Barik. The agreement with the competent authority already been executed and I have paid also all the dues.
The whole context is, Your Lordship, since the petitioner was the highest bidder and since 2 years have already passed.
We are saying this, that you may invite adverse observations against your client. What?
The bank guarantee has also been returned since 2022 when you declared this the instruction.
What do you want?
Your Lordship may pass orders. Your Lordship may pass appropriate orders.
The in September 2022, Tahsildar Jharban had floated an auction notice to lease out Bolangir Sand Quarry number 5, sand quarry for 5 years for the financial year 2022-23 to 26-27. Stop. The petitioner had participated and it is and asserts that he was found to be the highest bidder by the auction committee. Stop. Auction committee, and accordingly, he was intimated that he was the successful bidder through letter dated 23/9/2022. Stop. It has been asserted in the writ petition that the petitioner was suffering from serious brain injury and therefore he expressed his unwillingness to execute the deed for operating the said sand quarry through his letter dated 18/10/2022. Stop. It further appears that the second highest, that the bid quoted by the second highest bidder was found to be unreasonably low. So, however, later, the second highest bidder has been granted the lease in March 2024. Stop. The petitioner has now approached this court for quashing the order dated 15/3/2024, whereby the sand quarry, Bolangir sand quarry, is sought to be settled in favor of the respond numbers, opposite party number 6. So stop. And counsel appearing on behalf of the petitioner has submitted that it was because the petitioner's that since the petitioner was sick, he had expressed his unwillingness to enter into the lease agreement, and therefore lease agreement to stop. Now he is fit. Now he is fit, and now he has recovered. To stop. She contains that learned counsel for the petitioner contains that in any view of the matter, the settlement could not have been made in favor of respondent opposite party number 6, who was found to be the second highest bidder, but his bid was unreasonably low. His amount quoted was unreasonably low. Stop. Next. We are of the view that the petitioner has no locus standi to maintain this writ application once he had expressed his unwillingness to enter into the lease agreement despite having been declared a successful bidder. So stop. The plea that the petitioner was unwell and therefore he could not execute, therefore he had expressed his unwillingness to execute the lease deed is apparently an afterthought, as there was no such fact mentioned in his communication to the Tahsildar as the reason for unwillingness. Full stop. This writ application in the court's opinion is frivolous and is accordingly dismissed.
Item 13.
One of the reasons you withdrawn your, that you didn't want to say in the financial interest of the state, I want to take up. So,
Because the second bid was unreasonably
when
low,
you
Your
refused, you did not consider the financial interest of the
But
state.
it would have been beneficial for the revenue authorities
Had
as
you
well.
taken it?
Obliged, Your Lordship.
13.
The petitioner applied for a grant of NOC to opening up the DMLT course, my lord. For opening up a DMLT course, petitioner applied, my lord. And the opposite party not to detected some defects in his application, and pursuant to his letter, petitioner has complied all the defects. But till yet, no NOC has been granted.
My lord, later copy may be given to me
No, NOC for which
for
academic year?
24-25. Or DM for diploma in laboratory, medical laboratory assistant technicians, my lord. He has not given me a copy. What I have found from his copy, that letter was given to him in March for compliance of the deficiencies within 15 days. But he has complied after that date, that is in 27th of April, compliance. But what has taken steps? I will get the instruction, let it come next week. Let a copy be given to me. I am for opinion number 2, additional DM.
Opposite party number
2.
2. Let a copy of one copy or 2 copies? Let
copies
the number of copies of the writ application be served upon him in course of the date. List this case on 1 week for him to seek instructions and file affidavit if so required.
Item number 14.
CPC, dated 85/2024 has already been complied with, and we have already appeared the examiners.
Complied with.
My lord, in this case, there was a direction. On my submission from National Medical Commission, if the percentage is there, attendance, they should be allowed to appear. Now the question is to whether they have had the percentage or not. I will give a counter to that. And university may also give a counter so that my lord will get the necessary.
This is its mission.
Lordship, Lordship, NMC, OP number 5.
Yes.
Lord, in the last year, Lordship direction has been complied with. And Lord, in the meantime, Lord, the National Medical Council wrote a letter to the university stating therein that if the percentage of the petitioner is in proper, then he may be allowed for the examination. I have to check, Lord, if I short affidavit after 2 weeks, your Lordship kindly fix it so that I can fill a short affidavit in response to the letter issued by
No,
the.
what was the prayer in the writ petition?
His prayer
was to pray examination.
prayer is that he is to be allowed to appear in the examination.
So he has appeared in the examination.
No, in view of a Lordship's direction, Lord, interim direction, he has been allowed.
That is the publication of result will be subject to regulations.
Yes. Therefore, let's start the issue, Lord, if your Lordship allows 2 weeks time. Yes.
Now, so we can do now, since you have appeared in the examination.
Yes.
That was the urgent situation because of which we had to pass the order. So your publication of result will depend on the provisions under the regulations.
Yes.
All right, we can dispose of.
Whatever you're saying, subject to that, it will be disposed of. that they have appeared in the examinations,
Yes.
but their continuance or success will depend on whether they fulfill the criteria.
I just pass on this letter to your lordship, then based on that, your lordship may pass order. Just I have received it through your WhatsApp. With a memo, I'll just give it to Lord, so based on that, your lordship may
Percentage
dispose.
part, they are saying, your lordship, the earlier examiners I have been scored and passed, they are saying that if their percentage is on accordance with their guideline, then we are eligible to appear the examination, lordship. That we have already been appeared, lordship. Now they are saying that if that appearance subject to the earlier percentage has been secured, that have been got.
Right.
Yes, that I am agree, lordship. I have no objection to disposal.
You can't object. We cannot go against law. How many petitioners? 5. The petitioners approached this court by filing present writ application with a grievance that the opposite party number 3, that is Chief Controller of Examination, Sambalpur University, was not allowing them to fill up the forms for appearing in 3rd Professional MBBS Part 2 examination 2024, though they had cleared 3rd Professional MBBS Part 1 examination in October 2023. Stop. This matter was earlier taken up on 8/5/2024, and upon noticing a communication dated 21/3/2024 addressed to the Controller of Examination, following order was passed. Paragraphs 3, 4, and 5. So stop. Next, the petitioners have been allowed to participate, to appear in the examination in the light of this court's order, as noted above. So stop. Next, learned counsel appearing on behalf of
NMC, National Medical Commission. National Medical Commission.
National Medical Commission.
Yes.
And
Lord University, Biju Patnaik University.
Biju Patnaik University.
Sorry, Lord, Sambalpur University.
Sambalpur University have submitted that the publication of a result of these petitioners shall, however, be subject to the requirements, statutory requirements.
Yes.
Particularly their percentage of
Attendance.
requisite percentage of attendance in accordance with which regulation?
Lord, this is a medical education curriculum guideline.
Medical education curriculum guideline.
Guidelines dated 1/8/2023.
That is Medical Council's guideline, my lord. That is guidelines on the basis of the NMC. NMC guideline dated 1/8/2023.
1/8/2023. So this application stands disposed of with an observation that the results of these petitioners of the aforesaid examination shall be published in accordance with the statutory provisions / guidelines.
As per the National Medical Commission.
As per the Medical Commission.
That is there, above it is.
Taking into account
one thing, this supplementary examination, so what attendance will they fulfill for the supplementary examination?
No, because that is the guideline issued by the National Medical Commission. Therefore, we are not allowed them to participate in the supplementary because everything list upon we are not.
For some reason, for some reason, they could not
Appear.
appear in the supplementary, they could appear. Supplementary, they
I've just passed on this letter issued by the MNC. So
pass
that,
on.
yes, sir.
We will incorporate.
With a memo, I've just within
We will
30 minutes.
incorporate that part.
As you also, please.
We will incorporate that part of it.
As you
Who is the conducting council?
Devasis Nandamal.
On 2 weeks.
Item 16.
Online or something? Item 16. I asked him to online.
What kind of
Fresh admission notes.
and there is nothing Odisha ownership management.
The real estate something. Challenging the virus.
There's no representation on behalf of the petitioner. Let this matter on 1 week.
Item 18.
The petitioner prosecuting Bachelor of Ayurvedic Medicine and Surgery in the Institute of Opposite Party number 5 since 1.5 years. My lord, his examination is scheduled to be held tomorrow, but admit card was not issued on this score that the petitioner belongs to OBC category, but in his NEET UG examination scorecard and admit card, his category has been written as general caste. May I kindly see Annexure 2. The petitioner belongs to OBC category. Annexure 2. At page 13. My lord.
So what do you want?
My lord, my examination is scheduled to be held tomorrow. My lord, I may be permitted to sit in the examination pending this read petition.
Did you file another application and withdrew it yesterday?
No, my lord. My lord, my prayer is my caste is OBC, although I have committed, I have inadvertently I have made mention general category. My lord, in similar matter, similar parameter matter, the Karnataka High Court has granted such relief.
For a moment, let's see the Annexure 2, that is a OBC certificate issued by the state of Chhattisgarh. And that is an electronic application 22/2/2023.
Then how can you claim reservation here?
I have taken admission in direct admission taken in college.
Without need.
My lord, I have secured 93 marks. Kindly see Annexure 1, my lord.
my lord, cutoff mark for OBC is 1.
So you are not an OBC for the state of Odisha. You may be an OBC for the state of Chhattisgarh.
My lord. My lord, in all India quota, I can take admission.
General?
My lord, I belongs to OBC.
No, All India quota, are you allowed to take advantage of the certificate granted in your state? Have you checked?
No, sir. My lord,
You understand?
my lord.
Whether you are allowed to take advantage of take aid of the certificate which is granted to you in your state for admission in a medical college of another state.
My lord.
Mr. Padi,
Yes.
My
so
lord,
if it is all India, then that the benefit has to be granted, I
With
think.
regard to the certificate, Miscellaneous Certificate Act is concerned, each state have a different statute. There is a.
Exactly. But if it is all India admission, why should you not be granted benefit?
That's true. He's applied, but he is applied under the general category. Early.
My lord, kindly see, I have studied for 1.5 years. And kindly see, Annex 6, I have attended all the classes and expense near about 10 lakh officially and 20 lakh.
That is immaterial. You were admitted as a general candidate.
No, my lord, OBC.
In the time of submitting the application.
In the time of at the time of application, I was admitted in OBC category and continued. My lord, kindly see my I card, Annexure 5, and Annexure 6 is my attendance sheet. My lord, Annexure 8 is payment receipts.
What is the system of admission?
My lord, at the time of admission, I was allowed and I continued.
You were allowed by a private institution.
Oh, my lord.
So they can do anything. They are free to do anything.
My lord, the sole question is a change of category in the scorecard or admit card. I am OBC.
You may be OBC, but you are not having the certificate of OBC.
But Annexure 2.
Annexure 2 is subsequent to filing of your application.
My lord.
Is it not correct?
My lord.
And then you when did you obtain admission?
My lord, I am OBC since birth. Yes, I have obtained the certificate letter.
This is item
18, my 18.
So you are OBC by birth, therefore you can apply as OBC, though you don't have any certificate.
I have made
What
an
an
mistake
argument.
at the time of filing. My lord, kindly see, since 1.5 years I am continuing.
That is immaterial, Mr. Counsel. Please don't repeat that. This relief, you can file affidavit, we will see. We will not say anything. No entry order. File counter affidavit.
Use privilege. You file the counter.
My lord,
Issue notice. File counter. Yes.
Yes, my lord, we issue notice, man.
Yes, issue notice to the private opposite party.
My lords,
Also accepts notice on behalf of.
my lords, I have the instruction to appear for opposite party number 5, my lords.
Opposite party number 5, all right. You were admitted
my lord.
and then
My lord, I pray to sit in the exam, my lord. Till disposal of the repetition, repetition will taken time. My lord, I am permitted to sit in the examination. First
who
year.
is objecting?
My lord, they are not allowing.
On what ground?
Your caste is general written in the after 1.5 year. They are making not issuing admit card.
Who is not issuing?
My lord, kindly see Annexure 9.
Opposite party?
My lord, kindly see opposite party 5. Opposite party number 2, my lord. Kindly see Annexure 9, page 26.
Chairman was the-
Yes, sir. All the list were provided by the NCISM. 25 students documents verified successfully, and 2 numbers candidate Aditya Gosai, my lord, myself, are not eligible.
All right, we will allow you to appear at the examination. Subject to the condition that if you fail to satisfy, you will have to pay 50,000 at least.
My lord, obliged.
It is the petitioner's claim that he belongs to. Let us see the Karnataka judgment.
The judgment which you are relying on.
And whether OBC certificate was required to be uploaded at the time of filling up of the form.
Oh, there is.
What kind of claim you are making? You were required to upload OBC certificate at the
Yes.
time of filing of your application.
My lord,
You didn't do that.
my lord. Inadvertently,
Where is the question of inadvertently? You did not have.
no, my lord, I have earlier also obtained a certificate.
Where is that?
Did you have a valid certificate at that time?
Valid. My lord,
Where?
since 86, since 1986, my caste is OBC. In the central list, my caste has been recorded OBC since
Not that.
1986.
Caste
My
will
lord,
be recorded. Did you have a certificate?
No,
my lord,
because the annexure 1, let's make see
my
that
lord, certificate
7/9/2022, the certificate 23.
Annexure 6, where is your name?
my lord,
33.
my lord,
Percentage.
my lord, that's at
Which I got.
Annexure 6. My lord, 33, Aditya Gosai.
And same thing again. Look at your annexure 7. During NET application process, I was facing some issues in filling out form, and to avoid rejection of my application, I selected general category.
My lord, at that time,
Or they had given you admission on the ground that you belong to OBC.
OBC.
Mr. Behra, if the student was not eligible, how did you admit him, take fees from him, impart education to him?
My lords, I have the instruction notes where he has submitted an OBC certificate and affidavit, and then, my lords, there is a letter from OJE to the institution to take direct admission. And after that, the OJE was supposed to verify the document submitted by the student when direct admission is taken. So when we submitted the documents, then OJE said that there is a discrepancy in the document submitted by the student in the institution while taking direct admission and the application filed before the NET examination. Therefore, they are not accepting, my lords.
So this case is different for the reason that in this case, examination was held in January and request was made for altering the status in April. In that case, the court made these observations. Here you are making this request after 1.5 years or more than that.
At the time of admission, I have appraised all such things. And it was also brought to the notice of OJE.
Mister, we are putting a question whether it was a requirement to upload your certificate at the time of filling of your online application or not.
I'm in doubt. Although I'm not absolutely clear, but there is no need at the time of filing application.
How do you say it?
My lord, in the information sheet, you have to mark only category.
Have you filed a counter, Mr. Paddy?
No, the first time it is listed.
First time.
First time, when did you file your writ petition?
My lord, I have filed, it was listed.
No,
before
second time.
Single bench. It was erroneously listed before single bench. Thereafter.
Took up for 11-6, it was not take up, then.
19-6, 19-6.
The petitioner had appeared in NEET 2022-23. So it is his case that though he belongs to other backward class bracketed OBC, comma, inadvertently, while making the online application, he had entered quote unquote general. So stop. Based on his merit position in NEET 2020-23, he got admission in which college?
Opposite party number 5. Sri College of Sri College of Ayurvedic Research and Hospital under Sri Sai.
College of Ayurvedic Research and Hospital under Sri University, comma, in BHMS course.
BAMS, Bachelor of Ayurvedic
BAMS course. Full stop. At the time of admission to the said course, he had submitted a certificate of him belonging to OBC criminal. Not criminal there.
My lord, kindly see annexure. It's in the central list of OBC.
Where is your certificate?
My lord, annexure 2. Annexure 2. Does not belong to the category of creamy layer persons.
OBC bracketed non-creamy layer.
Fine.
Can you go? Non-creamy layer. So stop. Now when the examination, first year examination.
My first year examination.
First year examination is going to commence from tomorrow. Stop.
So they have to do
From 27/6 to.
It is his grievance that he is not being allowed to appear in the examination on the ground that at the time of making online application, he had entered general instead of OBC. Stop. Learned counsel for the petitioner has submitted that that was an inadvertent mistake. Stop. We will examine the contentions raised in the present writ application after the affidavits are filed on behalf of the parties. Stop. Considering the fact that the examination is going to commence from next tomorrow further, we direct that let the petitioner be allowed to appear in the examination. Have you submitted your application form?
My lord.
Stop. This interim order permitting the based on the today's interim order, the petitioner shall not claim any equity for the purpose of publication of his result and shall depend on final outcome of the present writ application. First of learned counsel for the petitioner has submitted that in case this his writ application fails, comma, he shall pay a cost of rupees 50,000. Since he is being allowed to appear in the examination by the present interim order based solely on the averments made in the writ petition.
My lord, cost maybe 10,000.
Not less than 50,000. These are extraordinary circumstances. You are compelling this court to pass such orders.
Item 19.
My lord, I have already submitted a memo not pressing the relief for compensation in the physical punishment in schools case. My lord.
In the Mr. Pradeep Kumar Das, learned counsel, has filed a memo to the effect that we shall not press the prayer pertaining to payment of amount of compensation comma originally comma which is part of prayer number 4 in the writ petition. So stop. Yes. Now make your submissions.
My lord, this petition is filed with the primary motive to take necessary steps for enforcement of section 17(1) of the Right of Children to Free and Compulsory Education Act in letter and spirit with a view to protecting children from physical punishment and mental harassment in schools throughout the state.
So which or what order should we pass?
My lord, a child has died after undergoing physical.
That we have understood.
Yes, my lord.
So in future, no child should die.
Should
This
die
is what-
or no child should be subjected to physical punishment or mental harassment in accordance with section 17.
So that is already there.
Yes, yes, my lord. That should be enforced by the state because there are also some other instances this punishment is being inflicted. They are not beating, but they are making the students to do sit-ups. That also amounts to physical punishment. And at the same
what
time,
should we do? Law is already there.
Mr. Das, the IPC is there, people are still committing crimes, so do we have to pass an order that don't commit crime?
no.
Then-
My lord, the state should enforce it
How?
in letter and spirit and to take appropriate action against the teacher found guilty in cases and to arrange training and sensitization programs. Training and sensitization programs.
So have you stated that nothing
Yes,
has been
yes,
done?
my lord, no training and sensitization. Actually, I have already filed an RTA application seeking number of complaints filed and action taken, but they have not responded, my lord.
That
I have also mentioned it.
you can file appeal, you can file second appeal.
Yeah.
That right to information is different thing.
No, but the purpose of PIL will be served if the honorable court.
Purpose of the PIL, this court is not PIO.
No. Actually, I am not asking for information, my lord.
Yes.
My prayer is to take necessary steps for enforcement of
step?
section
This is what we
17.
are
The
asking.
state should take and the state should arrange training and sensitization program for teachers regarding physical punishment and mental harassment in children. They should be sensitized teachers. So the purpose of the law will be served, my lord. No child will be subjected to physical punishment or mental harassment in future. In death is the worst thing, but not a single child should be subjected
So
to
if
physical.
we issue directions,
Yes,
and
my
despite that, someone is physical punishment is
then in the appropriate case, if they come
if any relief can be granted. That is a separate thing, the individual case. But for collective interest of the children in school, this PL may kindly be entertained by the Honorable Court.
Yes, madam, what is your stand?
Any order, your lordship may
No,
pass.
any order we cannot pass. It's like,
Let them file an affidavit.
law
my
is
lord.
there, enforce it.
Yes, your lordship, it's there.
This,
If individual complaints can be placed before the authorities, your lordship.
file your affidavit, we will see what are you doing. Eight weeks time is allowed for the estate to file counter affidavit.
Item 20.
My lord, any specific date may be.
8 weeks means 8 weeks. So after 8 weeks, your matter shall be listed.
Item number 20.
20, my lord, there is batch of cases, my lord, tomorrow it is coming, my lord, that is additional fees, your lordship. There is the Karnataka High Court decision, your lordship wants that, my lord, your lordship, batch of cases tomorrow, my lord, let it be come that they want tomorrow.
The old cases.
All cases, your lordship.
Why have you filed a new case?
No, my lord, this is another vehicle, my lord. All the data application, my lord, tomorrow, your lordship fixed, tomorrow, 27. Let it come, my lord.
Additional fees. Additional fees for what?
Additional fees of fitness, my lord, rupees 55, my lord. Your lordship already had that.
When was it last listed?
Your lordship, before vacation, my just hardly, my your lordship,
Does this matter tomorrow, does this matter tomorrow along with WPC number?
WPC, I'll give that.
Give the number.
I'll give it. I'll just give it.
We have it. There is no such batch coming tomorrow.
The 27th, my lord, they're fixing your lordship.
Give the case number, then only we
I'll
will.
I may be pardon item 18, urgent certified copy during course of the.
You can get. Again, certified copy.
Those in the PhD.
Matter? Opposite parties.
Item
Other opposite parties are required to be issued notice in your case.
OP5 had appeared.
My lord.
Mr. Padhi has appeared for whom?
NCSM plus
You
OG.
call him, because unless notice is issued, nothing can happen.
My lord.
Because somebody has to appear for OG also.
My lord.
Yes, yes. That item 18.
18,
Mr. Padhi was here.
my lord, he is on his legs, my lord.
In his legs, you tell him which party will he accept notice.
Fine.
All right.
Fine.
Examination. He might be for the ministry. But on that only, there are number of 5, 6 opposite parties.
Ministry of Finance.
Others notice has to be issued.
Ministry of Finance.
National Bank. File for 1, 3, and 4.
1, 3, and 4.
Man.
2, who is 2?
2 is who?
Two is OG.
Chairman, OG.
That somebody appears, I think. Mr. Satpathy.
He appeared for.
No. Who appears for OJ normally?
Senior counsel, Mr. Palit appears, so his associate can be served with a copy. OJ.
My lord served during course of the day. Now I am serving.
Associate name you have to give, or we will mention his name.
Lordship can, because each and every case, Mr. Palit only appears, as senior counsel.
You have to serve copy along with the order.
My lord, I am serving now.
Order is not there. How will you serve now?
No, it's to associates. Please associates.
Along with the copy of the order, read petition with the order so that he can comply the order.
My lord, I pray for the urgent certified copy during course of the day in item 18.
You are commanding us
No.
to get the order typed, correct the order, put our signatures, and bring the order to you in your chamber.
Sorry, sir.
And this you have repeated at least 4 times.
My lord, sorry.
Yes.
Item number 21.
One more thing. That it is to protect Bardand, that is the stretch of National Highway from Shingodwar to Gundicha Temple. From the user of that entire Bardand for commercial purpose during Rathayatra. People are see Rathayatra from 7 to 19. Municipality has placed tender. The matter was earlier before this honorable court. There are judgments which I have annexed. If a lordship will see that judgment, previously municipality has also undertaken and judgment in that line has already been passed not to use Bardand for commercial purpose, not to let it for any stall because it creates environmental problem and lots of problems over during Rathayatra. Now that judgment I have annexed. Municipality again for this year applied for permission to the National Authority for using it for commercial purpose. That application, if a lordship sees, page 22.
Boda Sankha to Gundicha Temple. Boda Sankha to Gundicha Temple. That is not Bodadanda.
Yes, that's Bodadanda. Bodadanda stretch of Bodadanda is 2.5 kilometers from Singadwar to Gundicha Temple. Boda Sankha in between a place from Market Chowk to Hospital Chowk, that's Boda Sankha, till Sangram Club. Boda Sankha is a place in becoming in between that over that Bodadand itself.
From where to where?
Boda Sankha comes a place, your lordship kindly remember that parking square.
Medical Chaka.
Medical Chaka and parking square in between. One more. That is Boda Sankha. And it goes up to Sardavani, Gundicha Temple. Now municipality, if your lordship see page 23, 22. This year, municipality again made an application to the National Highway Authority, page 22, para 1. I'm sorry, municipality's application, man. Page 20, man. Page 20.
What objection do you have?
Beg pardon?
What objection do you have?
What objection do you have in the sense, under section 38 of the National Highway Authorities Act, no commercial activities are permitted on the National Highway. This whole Bodadand is declared as National Highway since 2002. Now, on account of user of this land for commercial purpose, it causes lots of inconvenience for the general public. It causes pollution. It causes whole traffic, whole system goes wrong. They are over Bardhan during because about more than 10 lakhs of.
Where is that provision?
Section 38 of the National Authorities Act.
Why have you filed after the quotations were opened?
In fact, we were expecting that municipality will abide by earlier judgment. On this very issue, the matters were carried to this honorable court previously. If a lordship see the judgment passed by this honorable court, it was specifically stated in the judgment. Again.
Where is that?
Page
27.
Let's see page 32. Judgment starts from page 24. Page 24 of our brief manual. The whole issue is dealt with threadware. If a lordship sees, instead of taking a lordship to the facts and other issues here, lordship will see page para 11, page 32.
Let us see the act first.
Act, correct.
Section?
But it is Control of National Highways Land and Traffic Act. Your lordship is getting that.
Yes.
I have reproduced in the repetition. Lordship may see section 38. I have reproduced in the repetition also. If lordship.
It is at page 38.
May I be permitted to place it?
Just a minute.
Right.
Structure.
Structure.
Construction.
The temporary construction is covered by 38.
Yes.
But section 38, control of National Highways Land and Traffic Act 2002.
Construct, install, shift, repair, or carry any force.
Notwithstanding anything contained in any other law for the timing in force.
Yes, the law is very clear. Who is
Right.
for the corporation?
Over. Except
The
with the
National
prior
Municipality,
permission.
municipality has issued tender.
Except with the prior permission.
Right.
Yes.
Lordship, the notice has to go to Puri municipality, Your Lordship.
Some council appears probably.
Amitav Das and
Amitabh
That
Das
was
is for
the earlier
National.
case.
National Highway.
That was the national highway.
This matter tomorrow. Under the same heading, who is the
Senior Counsel,
managing
Mr.
director?
Senior Counsel, Mr. Pradipta Mahanti is for
Just a minute. The managing director. Bhubaneswar Municipal Corporation,
it is Puri municipality.
the managing director, Puri Municipal Corporation.
Puri municipality executive officer. I'm so sorry, Lord. I'm
Executive,
executive officer, Puri municipality.
Puri Municipal Corporation,
Municipality.
Puri Municipality is directed to join online proceeding. Since we have been informed that there is no standing counsel for the Puri Municipality for the High Court. Stop.
Was the authority who floated the tender.
Is the executive officer, Puri municipality. That's annexure 1. Grateful. Allegation.
Considering the urgency of the action. Considering the urgency.
May I please, Your Lordship?
They are not having any sign of the notice.
How could they give permission? He says no, but.
Lordship's order has been complied with and he appeared.
Item 23.
Lordship's pursuant to Lordship's direction, I filed that Lordship's affidavit giving the names of the persons who were in charge of that office. And simultaneously, we have also paid that the OP number 2, that is the director, he will make it convenient to pay the dues. He has separated for 2 months' time, but 15 days before Lordship's grant, it shall be paid. But I have given the names pursuant to Lordship's direction. Lordship. That affidavit is filed today, but through email, I mean through e-filing, but it may not be there in the. Yeah, it's got all copy. That's the one.
This will be officers. From the report of superintendent for Odisha State Union Board of 11/2019 date filed by way of an affidavit. From they say that the affidavit is not there on record. This matter of 2 weeks, week on week. with the affidavit from the court. When the court will get taken off. Persons responsible for disobedience of the law.
Right.
All right, so you have enough indication.
Yes, please.
Item number 24.
No, item 24, you also directed the opposite party to comply the order, but they have not yet complied.
Once order has been complied with, I don't know if I can give a copy to my learned senior because not there.
Paspati,
My lord,
the order has been complied with. This is what it
let
says.
them supply a copy of the order.
How?
Your lordship will direct them to supply copy to the petitioner or me, my lord.
What was the order?
Because if you also look at the order of this honorable court was page 9, paragraph 5 of losses briefness.
So the decision was required to be taken. That decision has been taken. So we are dropping the contempt proceeding with the liberty to challenge the decision.
Yes, please.
If that is against.
So he can challenge because it has been not rejected. He can challenge it also. Not.
So with that liberty, we can dispose it. All right.
Yes, yes, my lord.
It is stated by.
Visit by vision.
This court order dated 2023 has been complied with. And as the inspection has been taken on the application filed now for petitioner, which was annexure 8 in the writ application, was stopped by said decision, the petitioner's application has been rejected. Stop. Next, in such view of the matter, this contempt application, the contempt proceeding is dropped with an observation that the petitioner shall be at liberty to question the correctness of the decision dated
Yes. 2nd of November 2023.
6/11/2023. Is that an order?
Yes, it's an order.
Decision order passed by
Passed by the Additional Chief Secretary, GA Department. Below.
Additional Chief Secretary, General Administration Department, Government of Odisha. Contempt proceeding. Yes. Next.
Item number 25.
May I please, my lords. The order dated 5/2024 at annexure 1, my lord, has not been complied. The relevant portion, my lord, is page 26 last paragraph, my lord. Earlier, the writ petition was filed, my lord. This is with regard to the Delhi Seva Puja of Lord Jagannath, my lord. The Honorable directed to revive the said Seva Puja within 3 months.
Now, what is the order?
Order, my lord, your paragraph 12, my lord. Lordship, page 26. Last portion, you lordship allow me to place. In view of the above, this court is of the considered view that hereditary seva of the deity, which has been found place in the record of rights, should not have been stopped on the plea of financial crunch, when huge amount of money is being spent for the purpose of development of the temple and its administration. There is no dispute before us that different categories of sevakas are discharging their responsibility for different sevas and nitis of Lord Sri Jagannath. Dhanadhikya seva number 119 being one of the such sevas as mentioned in serial number 7 of the record of rights should not have been stopped by the authority merely on the ground of financial crunch. Therefore, in the interest of justice, equity, and fair play, this court directs the temple administration, that is OP number 4 and 5, to revive the Dhanadhikya seva, taking into consideration the grievances made by opposite party number 6, the petitioners and other devotees under Annexure 9 series, as expeditiously as possible, preferably within a period of 3 months from the date of communication of the judgment, my lord. This order was communicated to the OP number opposite party on 23/2/2024.
Notice go. Issue notice. to the non-appearing opposite parties.
Or orders item 26.
Wait, please, Your Lordship. This is the final disposal, in fact. An application was filed by my state for vacating the interim order. So you should hear the matter finally.
We can hear the matter finally.
Yes. If you should hear it today also, I am ready.
You can hear. Is it a long matter?
It will take 10, 15 minutes or half an hour.
So what should we do? We can pick up the matter tomorrow? Tomorrow we have the wedding. Tomorrow at 2 o'clock? Tomorrow at 2?
Yes, tomorrow I have personal difficulties, my lord. Friday, my lord.
Monday or
Or
Tuesday?
Monday.
Monday or Tuesday?
Monday, my lord, at 2 p.m.
As this matter has been placed under the heading for orders to consider an application filed on behalf of an opposite party to respondent vacate an interim order of stay.
Right.
Learned counsel for the parties agree that instead of taking up the interlocutory application, this court may hear the case, the appeal itself on merits. As jointly requested, this matter on Monday when this appeal shall be taken up for final hearing.
But interim order to continue.
Interim order shall continue.
Grateful.
2 p.m. 2 p.m.
Mr. Acharya, please give us a date chart. Date chart.
Item number 27.
In this matter, in the morning hour, one of my friend was asking for time. My lord, since the notice to other opposite parties have not been made sufficient, so I pray, my lord, let this matter be called after 3 or 4 weeks, so that in the meantime the notices issued in favor of 18 respondents, let them be made sufficient. Let those notices issued from this honorable court be made sufficient in the meantime. So the noting has come that it has not notice has not been made sufficient. So I pray let it be called 4 weeks. After 4 weeks or 3 weeks, as per your lordship's convenience.
Item number 27. You are accepting notice on whose behalf?
Well, I am for the appellant.
You are for the appellant.
I am for the appellant.
In the appeal in WA 85, I am for opposite party 4.
And 86?
In 86 for opposite number 8. And 88 opposite number 8.
It is 6, you are for opposite part number 5.
8.
8.
No, you said WA 88 for respondent 8.
Yes.
For WA 86, respondent 4.
Number 8.
They're also 8.
These matters on 4 weeks awaiting service of notice upon non-appearing respondents. The let tracking report as regards issuance of notice through that was through speed post. Speed post or registered post? What was it?
My lord, registered post.
Tracking report be placed on record. That's be placed on record.
Okay.
Just do he version return also, we have to take a guess.
Yes.
Okay.
28.
28, my lord, notice returned undelivered. Notice returned undelivered with a remark that R3, R7, 10, 14 and 17, the addressee are deceased. So fresh steps are being taken for substitution.
R4,
R3, R7, 10, 14, 17.
or no more. Then
They are deceased. Addresses. So fresh steps are to be taken for.
Deceased.
Yes.
Deceased fresh steps or steps for substitution.
Yes. So steps for substitution is required to be taken.
For ones who are
Yes.
dead. Once who have returned unserved, then fresh steps.
Yes. I'm sorry.
in view of the service report to the effect that respondents number 3, 7, 10, 14 and 17 have that learned counsel for the appellant seeks adjournment to file substitution applications. Full stop. For the said, but how much time will it take? Let's this matter. Who is appearing for the other side? Other opposite parties?
Nobody has entered appearance.
The number of parties is the problem. 20.
Matter on 8 weeks.
Item 29.
29 may be taken up tomorrow.
29 identical, the very same judgment has been challenged in another writ appeal that is pending, your lordship. This may be tagged and heard together. This is the writ appeal, your lordship. Your lordship have issued notice and passed interim orders.
That is, which case is that?
That is writ appeal number 47 of 24, filed by the respondent number 2 in the present appeal. Challenging
I filed it.
challenging the very same judgment. So
Not same, very same judgment. Judgment is different, my lord. In one judgment, state government has challenged that whether that college is aided college or not, my lord. That state government has challenged. I have challenged the final judgment of that case. In writ petition, 2 judgments have been delivered. Preliminary question was raised whether this institution is an aided institution or not. Whether that the Odisha education, recruitment and condition of service.
So there are 2 separate judgments.
2 separate judgments.
Pass in one writ application.
In one writ petition. State government has challenged that whether that the honorable single judge held that the Odisha education, recruitment and condition of service is applicable.
Just a minute. This appeal along with WA number
47 of 24.
47 of 2024. On when is that matter coming?
That matter, no date has been fixed, my lord, notice has
no date.
The matter was supposed to come on 5/3/24. It was on the board, but thereafter it was
that notice was not made sufficient, therefore.
1 week or 2 weeks after. Next week or a week after.
Next week, I file a petition, my lord. On 2 weeks after.
2 weeks.
2 weeks after.
Condonation of delay application is here.
12 days delayed. That may be condoned.
12 days.
higher numbers also. Delay of 12 days and within the appeal stands control.
Dispensing with all.
Dispensed with.
Item 30.
Copy of the appeal memo may be served.
Well, copy of the appeal memo may be served.
Served.
Item 30. There is a delay of 184 days. The issue is
If you notice,
the respondent was working as a driver, was appointed on a daily wage basis on 44 days basis. He was appointed as a driver in Mahila Vikas Samavaya Nigam.
so we are issuing notice
Mala.
limitation
Dispensing with all.
dispensed with.
Item 31.
May I please, matters. The judgment passed by the Honorable Single Judge under challenge, there is a delay of around 72 days, my lord. The judgment was passed on 1st of September 2023, and this appeal has been filed of 12th
Yes,
of.
any objection?
I'm appearing, I have the instruction to appear for the sole respondent, my lord. Let him serve me a copy so that I can give objection to that. I know there are 73 days delay in filing the
So
appeal.
delay can be condoned, no?
My lord, I'll show that here is a case, the plea taken delay cannot be condoned. The plea taken for delay of condonation cannot be accepted by laws. I'll give objection to that. Let him serve me a copy. I have instruction to appear for the sole respondent. Read application, read appeal, and also the limitation petition.
Also accepts notice on behalf of the sole respondent in the limitation matter as well as main matter. To stop. As requested by senior counsel to file an objection to the limitation application. Let the matter be listed on under the same heading on 2 weeks.
Item 32.
Mr. Rath, you appeared for the sole opposite party
Yes, ma'am.
along with
Along with D.N. Rathan, Soroblas.
Item number 32.
32. If there is a delay of 503 days, the Honorable Single Judge disposed of the writ application referring to the judgment passed in case of Saraswati Bhoi. That matter is sub judice before the Honorable Apex Court, and there the interim order is operating. The judgment passed in case of Saraswati Bhoi has been stayed by the Honorable Apex Court. So, Lordship,
If you notice.
Item 33.
but there is a delay of 271 days.
And I have already filed my objection. Your Lordship kindly have a glance to my objection. And they have not explained the sufficient reason why there is a delay of 271 days. And by virtue of, and your Lordship, the order of the decision of the Honorable Supreme Court, each day delay has to be explained, madam. I have page 5, I have mentioned all the judgment of this Honorable Appeals Court.
On what point?
The respondent submit here that this appeal is liable to dismiss on the point of limitation, and the respondent here relies on the following judgment passed by the Honorable High Court as well as the Honorable Supreme Court. And another thing is that you will also, after disposal of the content petition, they have filed this writ of appeal. Para 4 as well as para 5 have mentioned the reason that the delay should not be condoned. And after rendering 25 years of service, the Honorable Single Bench has directed the petitioner, respondent to be observed in a regular establishment. And when that has not been complied, I will file a contempt petition. And the Honorable Single Judge has directed for extension of 1 month time to comply the order. And thereafter, they have filed the
Extension of 1 month after hearing them or
to comply the order.
first date?
Now, you will also, para 4, you will also kindly have a glance.
Where is that order? Contempt.
That order is, I am not enclosed, that order is in separate, you will also kindly have a glance that order.
Yes, what is the ground to challenge?
Lord, the petitioner continuing as a was continuing as a computer program. That post was not a sanctioned vacant post. She approached the Honorable Court before the Honorable Single Judge, claiming regularization of her service. It was specifically averred in our counter affidavit that no such sanctioned vacant post is there. Then pursuant to the direction of the Honorable Court, a specific affidavit was filed by OP number 2 that no such sanctioned vacant post of computer programmer is available. Now, the Honorable Single Judge, without giving any finding with respect to the continuance of the petitioner against any sanctioned vacant post, directed only on the ground that since she has been continuing for last 20 years, she has to be regularized. In absence of any specific post or
No, there is
vacancy.
no finding that there is any sanction post, but
Yes.
the court says that since he worked for 20 years, that means that there was a post.
Yes.
There was a requirement of post, that post was required to be sanctioned. This is what the what has been held by the London Single Judge
But,
in paragraph 6.7.
but in the meantime, the judgment rendered by this Honorable Court in case of Ravindra Panda, is the latest judgment 3 days back, my lord. I have the copy. I'll also produce that copy. There, your lordship have have held that 3 ingredients are required to be fulfilled. One, the petitioner must have been recruited through a valid recruitment process. He must have continued for a considerable period, and his continuance must be and should be against a sanctioned vacant post. So, the first ingredient, that she was recruited through a valid recruitment process, that is not fulfilled. Number 2, the continuance may be for a longer period, but it was not against any sanctioned vacant post. So that judgment also I am relying, that is by this Honorable Court.
Where is that?
Ravindra Panda, Ravindra Patnaik.
Ravindra Panda.
Twentieth June.
Yes,
20th May,
that was delivered on 18/6/2024.
18/6.
Have you examined this?
No, that document I have not
Examine it.
read a copy.
London Council appearing on behalf of the appellant states that the case is covered by the law laid down by a division bench of this court in court dated by this court in its decision dated 18/6/2024. In WA number 1193 of 2022, bracketed State of Odisha versus Ravindra Kumar Patnaik. Stop. Learned counsel for the appellant seeks adjournment to consider this decision. To stop as requested, list this matter on 1 week.
1 week after.
1 week, yes.
Yes.
My lord, I pray, my lord, item 38 may be adjourned to next. Item 38 may be adjourned to next week.
38, which item was taken up? Then after,
I'm not ill, I'm ill.
you are not well.
Right.
All right. 38. When do you want?
Next week.
Next week, 38.
Five, six other matters are there, no?
Thank you. Judgment is which item?
1.
No, but that e-file is there.
E-file was not there, which
Not
went
there.
for, we here.
Huh?
Horgu they not.
Incorporated. Where? Item number 1.
But the writ petition section, then I khali fill of everything was there. But today only this is there. Pen drive tane asle tar chila. How you can do it?
Just try.
Pen drive ta kote kila ne asle multiple approach magere.
It will take half an hour, Mr. Ratra. We are declaring a judgment. So it will take half an hour. Sure.
Another matter where
Yes.
we all are appearing, the batch of matters where the virus is challenged. Just now a counter was filed and copy was served. If you also will keep it to next week, any date, convenient to also at 2 o'clock.
Which date?
Next week?
Next week.
Next week.
For a week.
For 1 week after. 1 week after.
1 week.
Yes, ma'am. Why I am saying that in place of next week, 1 week after.
Okay.
Yeah, the virus of the act is under challenge. Their advocate general may.
2 weeks then?
Well,
I don't have any.
any
Is there
day.
any urgency?
All right.
Yes, sir. We have been suffered because those who are eligible, the result is not declared. A single judge has passed an interim order not to declare the final result.
That is.
We are in talk of the statute and we are eligible for consideration. But even we are not allowed to be a party to the case, though we are affected and an aggrieved. Therefore, let's see, fix a date, any date, it can be disposed
Yes,
of.
yes, yes, ma'am.
Any date, let's see, fix it can be disposed of.
If this matter is decided, all the matters will be covered, my
For
lord.
last 1 year, post has not been up, more than 100 posts has been lying back.
There are two sets of cases. There is completely different. One is simply challenging the virus. Another is challenging the virus and also the zone of exclusion from the zone of concentration. Anyway, let's not.
We are always prepared.
Let us not waste your lordship's time.
You have to prepare yourself. We are always prepared. So,
Right.
And moreover, there is a reference today also.
Today?
Today.
Today.
Tomorrow.
20.
Last Friday.
I'm sorry. Because the notice came, I didn't see the date.
So it will come after 2 weeks, 2 p.m.
Let's not.
We are giving you
process.
let me be date.
2 p.m.
Quite out.
59.
11th July at 2 p.m.
At 2 p.m. Oh, all right.
Jointly.
And item number 45, that Ron Giri matter. Your Lordship has only directed me to give a.
Yes.
And that your Lordship only that this may be incorporated in the order. I have given the copy. That the development he has given both the experts. If your Lordship will say, I will give a soft copy to the court master.
Please give us that.
No, I have given the hard copy. Only the for this purpose your Lordship has fixed the case to sort out.
Item number 52.
That you will do.
59.
You also adjourn that matter to 11th, that is item 59. That one.
59 will come on
11th.
11th.
Mr. Palit,
Whether any other matter has been fixed at 2 p.m.
Yes. 52 is a very short matter. It won't take much time. 52 is also another batch case. This can be, if it's fixed at 2 p.m.
It can be taken up today.
It can be taken.
So we can take up your matter first, then we'll dictate the judgment.
I am ready with the case.
May I be pardoned, my lord? Item number 40 and 41, both the matters, my lord, writ appeals, my lord, wherein there is a 52 days delay. My lord and senior is appearing for the respondents. So he says that the delay and merit, both the matters can be taken up next week. I should hand over him a copy of the writ appeal, my lord.
One more submission, my lord. One more mention, my lord. One item number
41, 40 and 41. 40, 41 next week. Yes.
So sorry.
Yes, please.
Item number 56. Similar is the situation, it is fixed at 2 p.m. But then it's a matter where I think I had talked to Mr.
We need some time to add to that on behalf of the state government. Lordship may adjourn the case to some other. Please, virus matter.
No, not virus. That's a telemedicine matter.
Telemedicine matter. I'm sorry.
Telemedicine matter.
He is also appearing in one of the cases. Mr. Rath is also appearing in the case.
Yes.
So, playing the matter, it will take some time. Your Lordship may fix it 2 weeks.
8, 10,
2 weeks, then 3 weeks.
3 weeks.
And it not be the same 11th, my lord, as your lordship.
Therefore, not 2 weeks. 2 weeks, 11th, that matter is coming.
Is 18.
Therefore, 18 July.
18 July.
18, no, 17. 23rd of July is the date available.
Little
Early.
Yes.
Little early.
Little, because the issue of payments are involved there in other matters, my lord.
Second week and third week, all dates are
Booked. All dates are booked.
Booked. Well, let me try my luck on the same 11th. If both the matters.
All right.
So great.
11th.
My lord, 11th, I am appearing in one of the matters. I won't be there. 11th. Yeah,
My lord
56.
said that
Someone.
56.
All right, it will come on
11th will come in 11th.
Good item 52.
Yes.
Item 34.
Since item 52, my matter has not come, since it is being adjourned, I will give the slip to court master so that my case can also be.
Has not been adjourned.
No.
52 has not been added.
I'm sorry. I'm wrongly informed.
Item 34, my lord.
Has not come. Since.
Item 40, Lordship remembers that INCO matter where the valuation was to be given. They are just handing over, they have not yet. So Lordship may call it At least in a week, I'll come back with the diploma.
1 week as requested.
Item 34, my lord. 34.
Interim order.
I am appearing for the respondent, my lord.
Orders and-
Item 34, my lord. I am appearing for the sole respondent, my lord. So my appearance was accepted and I put up this matter 1 week after, my lord.
So you file your
Power, my lord.
Wakalatnama in registry. File your Wakalatnama in registry. Matter will come afterward.
Today, the board, my lord, item 34.
34, 1 week.
I have a prayer.
I mean-
Item 52 may come next week because there are some cases are not come. I'll give the.
No, he is
52.
ready to argue that matter.
But my matters have not come. So I'm ready to the matter.
No,
Next week, any day, my lords may fix up.
very difficult
I don't
to
know whether he
adjourn
has
matters.
My lord.
Very difficult to adjourn the matters and fix a date because it becomes very difficult to, in fact, as the court master said that all the dates are booked.
Second start letter.
This may be taken as an exceptional case any day, my lord, next week at any time.
So make a.
Convenient to my lord.
No, 52 he is arguing.
I requested him that it be accommodated with us.
My learned senior actually wanted it today at 2 p.m. So
And
accordingly.
on that day, I have made a mention, but my matters have not come. That's my problem.
Also the file is there. Also the file.
This is a batch of cases. The batch of cases, my lord, some.
It's a batch of cases, but a very short point is there. It won't take much time.
So we can take up the matter tomorrow then. Tomorrow, tomorrow, 2 p.m.
Tomorrow, Friday night.
Thursday.
Yes.
Tomorrow.
My
We'll
lord,
do it tomorrow.
I may be pardoned to make
Interim order to continue. There's an interim order already passed that may be extended.
My lord,
Tomorrow at 2.
I may be pardoned. Item 58, I may be permitted to withdraw the case to pursue before the OP number 3.
Okay. Because liberty to pursue.
Matter before the OP number 3.
Item
Opposite party number 3.
Item 44 interim order to continue. Interim order.
All the matters will come tomorrow.
No, it has been adjourned. 44 has been adjourned for.
44 has been adjourned.
44 and hiding an affidavit.
File that in the.
Interim order to continue.
Hey, interim order, that order has been passed.
Interim order.
Yes.
Is extended from.
That has been passed.
I'm okay.
My lord.
My lords, item 56.
56 is adjourned to a particular date.
Yes, my lords. I was just praying, my lords, it's been adjourned to 11th. 11th, I have some personal difficulty. May it come up on the 15th or 16th?
Very difficult. We cannot fix our this thing. Cases like this, Mr. Khalid. Sorry.
Mr. Palit, one item 18. The student was supposed to appear in the examination. We have asked, because of urgency, we asked to serve a copy on you. It's a BMS examination, that's Sri University.
Okay,
Serve copy.
is it coming tomorrow?
No, the examination is tomorrow.
So,
They'll be subject to final order. But
Mal,
it's been asked to serve copy.
I'll instruct them to allow these. Provided he has to serve me the copy, I'll know the identity.
Item number 45, I have given the, well, only your lordship is to incorporate it in the order. That is the direction I have given. If your lordship will direct, I will give the soft copy. Only the development part your lordship has directed me to that. Both of them are signatories to this. Both the experts.
Item 45.
Each.
That expert has appeared, had appeared. He had suggested that scheme.
Order is yes, very clear. Yes.
I will speech. So many.
What is the last order?
Last order is was today. It is 25. 25 order was there.
Reference may be made to this court's order number 87 dated 25/6/2024. Pursuant to the observations made in the said order, certain points have been points as formulated by the experts, namely Dr. V. Sampath, fisheries consultant, and Dr. Ritesh Kumar, director, Wetlands International, South Asia, has been produced before us by Mr. Mohanty Learned AG, which reads as under. Oh, from top to bottom. Full stop. The case is adjourned. The public interest litigation is adjourned to 8 weeks. 8 weeks. Full stop. In the meanwhile, the court expects the opposite parties are states. Opposite parties, state of Odisha, to consider the aforesaid points for formulating a draft comprehensive fishing policy for Chilka. That's all.
Yes.
Pen drive only. Pen drive only.
Item number 1 for judgment.
You don't have.
Okay, it's giving. Follow.
Yes, you can. It's going to be a very short judgment.
Just now incorporating in that.
is, we can everything incorporate for the very good. Subscribe for you, if you can do it online also, you can do it.
In exercise of the power under proviso to section 3 and article 309 of the Constitution of India, the state of Odisha has framed Odisha Diploma Engineers Service bracketed methods of recruitment and conditions of service bracket close rules 2012, which lays down, in specific terms, the method of recruitment for the post of in the cadre of Odisha Diploma Engineers Service. So stop. Before the aforesaid rules were framed, the posts of diploma engineers were being filled up based on a panel of candidates prepared for the said purpose. So stop. Next is an admitted fact that as on 31/3/2012, total vacancies in different department of the government was these rules came into force with effect from which date?
That 31/3/2012.
No, but why this 2000?
This was
these
not
vacancies were being filled up through that panel.
Well, that rule was not given effect to.
This is what.
Yes, ma'am. Because as the panel was there, since the origins were there, so from that panel appointment was given. Subsequently, it was given. Your Lordship has seen that page 85 of that notification. Your Lordship has seen page 85.
Which notification?
That the Your Lordship has page 85 of that writ appeal. It was extended till.
Which notification was extended?
The government issued a notification extending that rule is to be operative from 31st January March 2013. You also can find it from page
31st
March 2014.
31. The said rules, rules came into force on the date of their publication in Odisha Gazette, that is 5/1/2013.
Yes, ma'am.
Stop. It is also an admitted fact that by subsequent notification, comma, the date, effective date of enforcement of the said rules was modified and extended to 31/3/2014. There is no doubt about it. Stop. Next. The total number of vacancies in different department of the government was 27. Total number of vacancies against the posts of diploma engineers, diploma engineers.
Yes, ma'am.
Stop. A requisition was, however, made for filling up 1,869 posts leading to 1,869 posts. Stop. Based on the said requisition, comma, 1,692 posts were filled up. Stop. 257 posts.
Sorry, madam, may I 1,612.
692 we are getting.
Lordship, you can find it page
12 or 92?
12.
12.
That
Yes, you are right.
Minus.
12.
Sorry.
1,612. There is a typographical error in
Yes,
this.
yes, madam.
1,612 posts. Then 257 posts were not filled up. So stop. The next. The sole question which has arisen in the present intra-court appeal for determination is as to whether the state is under obligation to follow the practice of filling up the posts which were vacant prior to 31/3/2024 based on the past practice, comma, from the panel so prepared or in accordance with the statutory rules framed under the proviso to Article 309 of the Constitution of India. This is the only question?
Yes, sir. 2014, it will also be dated 24.
2014. This is the only question?
Yes, madam, because by the notification, they
Yes,
say
yes.
existing post should be filled like this.
This is the only legal question. All right. Next. We have heard Mr. Sapan Kumar Pal.
Kishore Kumar Patel.
Mr. Kishore Kumar Patel. Your name should have appeared. Kishore Kumar Patel, learned counsel for the appellants, and Mr. M.K. Kutia, learned AGA for the state of Odisha. So stop. The How many appellants are there? The appellants have put to challenge in the present appeal an order, a judgment and order passed by a learned single judge of this court dated 17/8/2022 in WPC's bracketed OAC 2645 of 2014, WPC bracketed OAC number 1048 of 2014 and batch of cases. Stop. The facts of the case, the facts are not at all in dispute. The appellants are diploma holders in engineering in different disciplines. Stop. There was a procedure being followed by the state government of Odisha of maintaining a panel of diploma engineers for their appointment as junior engineers. So stop. The based on the said panel, names were sponsored by a committee of chief engineers and engineer in chief in different departments under the state government as well as public sector undertakings. So stop. In the meanwhile, the rules as noted above came to be notified, laying down method for regulating the method for recruitment. So stop. As has been noted above, the rule were made effective, rules have been made effective from 31/3/2014, exercising power under Rule 19 of 2012 rules, which reads as under. Rule 19 court order. Apparently, admittedly, comma, till 31/3/2014, comma, the appointments were made based on the panel so prepared. Appointments were made from the panel so prepared of candidates having diploma qualification. So stop. It is next. It is apparent from the records that when an records that in accordance with the provisions under the rules, the Odisha Public Service Commission issued an advertisement on 4/8/2014 inviting applications for filling up the posts of junior engineers by way of direct recruitment. If we are committing any factual error, please, you can point that out.
Yes, Malay.
Direct recruitment is direct recruitment. First off, the said advertisement was challenged. Said advertisement was challenged by filing OA number 62645 bracketed C of 2014 along with batch of original applications before Odisha Administrative Tribunal, mainly on the ground that the posts which were vacant prior to coming into force of 2012 rules ought to have been filled up from the existing panel of diploma engineers. So stop. The tribunal disposed of the said OA number 2645C of 2014 and batch with the following observation as has been noted in the impugned judgment of the Honorable Single Judge, paragraph 8 में 21 को quote कर दो. So stop. The said order of the tribunal was challenged before this court by filing a writ petition, by filing writ petitions giving rise to WPC number 8877 of 2017 and batch. So stop. By an order dated 28/2/2019, the order passed by the administrative tribunal was set aside and the matter was remanded back to the tribunal for fresh adjudication. So stop. During the pendency of that tribunal stood abolished. No?
No, my lord. Yes, tribunal was abolished in 5th May 2019. That matter was pending. Tribunal was abolished on 5/8/2019.
This is what we are saying.
Yes, yes, ma'am. That during pendency of that original after remand.
During the pendency of the original application on remand,
well,
before the administrative tribunal, Odisha Administrative Tribunal came to be abolished, and accordingly, the original applications stood transferred to this court and registered as WPC OAC number 2645 of 2014 and other similar matters. So stop. This is the brief background in which the matters were heard by the learned single judge. So stop. It was urged before the learned single judge that all the vacancies as on 31/3/2014 were to be filled up from the panel, and the action of the government in allowing the commission to go for direct recruitment in accordance with 2012 rules was illegal. So stop. The learned single judge, however, has rejected the contention, relying on a Supreme Court's decision, mainly relying on the recent Supreme Court's decision in case of Anurag Sarma and others versus State of Himachal Pradesh, reported in 2022 SCC Online SC 860. So stop. Next, Mr. That's all. Mr. That is all.
Yes, ma'am.
Mr. Patel.
Second advertisement was issued after dispute during pendency of the original application.
The only question is, does they have any right to be appointed?
Second
from the panel? If that is declined, then nothing else. Mr. Patel, learned counsel appearing on behalf of the appellants, has vehemently argued that admittedly as on 31/3/2014, large number of vacancies of diploma engineers were available. So stop. The panel was still surviving as on 31/3/2014. So stop. He has argued that it is an admitted fact that out of total number of vacancies available on 31/3/2000, total number of vacancies, only how much? Total number of vacancies?
2773.
Vacancy, that is 2773. Requisitions were sent for 1,869 posts only. So stop. Those 1,869 posts ought to have been filled up from the panel, and till all those posts, that is, all those number of posts, that is 1,869, were not filled up, comma, the state ought not to have filled up from the panel. The state ought not to have proceeded for appointment of junior engineers on the basis of direct recruitment in accordance with the rules. So stop. He has submitted that this is an admitted position, that out of 1,612 posts against which the 1,869 posts for which the requisition was made, only 1,612 posts could be filled up, and 257 posts still remained vacant. So stop. He contains that it was obligatory on the part of the state to fill up these 257 posts at least from the panel. This is your submission. Stop. He has argued that there is no justification, there is no plausible justification available on record put forth by the state why those 257 posts could not be filled up from the panel. So stop. He has heavily relied on a constitution bench decision of the Supreme Court in case of Sankarsan Das in support of his contention that though the appellants do not have an indefeasible right to be appointed against the vacant post, comma, the state cannot refuse, could not have refused to fill up the vacancies without any valid reason. So stop. He has also argued that the learned single judge has not duly appreciated the law laid down by the Supreme Court in case of Anurag Sharma and others, bracketed Supra. in support of his submission, this submission, he has relied on paragraphs 23 and 29 thereof. Full stop. Mr. Khotia, London AGA, representing the state of Odisha, on the other hand, has submitted that only because the names of these appellants were there in the panel prepared for filling up the post of junior engineers / diploma engineers, they did not have any indefeasible right to be appointed against the vacant post. Stop. He has further argued that there is a reason why those 257 posts were not filled up from the panel stop, referring to the specific averments made in the counter affidavit. He has submitted that those 257 seats could not be filled up as they were reserved for reserve category candidates and eligible candidates.
Let's say ST and SC. ST and SC, because reserve also SCBC. You'll also specify that ST and SC.
ST and SC were not available, and therefore the said posts could not be filled up. So he has accordingly submitted that the Supreme Court's decision in case of Sankarsan Das has no application in the present set of facts. He has also argued that the Supreme Court's decision in case of Anurag Sarma bracketed Supra has rightly relied on by the Supreme Court, wherein it has been categorically held that the posts vacant prior to coming into force of the rules are required to be filled up in accordance with the subsequent rules framed subsequent to where is that?
That your lordship can find it from paragraph 83, my lord.
No. Paragraph
83.
Oh no, in this case.
Yes, ma'am.
In Anurag Sharma.
Anurag Sharma. Lordship is holding that reported judgment SCC online.
SCC online link.
I am giving that a copy of that is.
Yeah, please come to paragraph page 58. 58. This is that's all.
One point I said it was extended till 2018. Page 262 and 63 of RIT 8877 of 2017. They again relaxed the rule in 2018 also. That point.
No. Where is that?
That is page 362 and 363 of the RIT petition. 362. Whereas views of law department was sought on the proposal of engagement of left out 363 numbers of diploma holders, law department opined that any appointment after so and so made under the diploma service methods, which would be total violation of said rules. Now, if you may turn 363, last 4 lines. Now, therefore, government, after careful consideration, do hereby relax aforesaid rule as one-time measure in order to give appointment to the 63 left-out candidate as a special case by invoking Rule 19 of Odisha Diploma Service, Rules 2012.
He has also brought our attention to why was this done?
Let that party.
That is connected to
Follow.
Yes.
He has also drawn the court's attention to an order dated 11/10/2018, whereby the state government relaxed the rule by one-time measure in order to
comply the order of the tribunal, madam.
in order to give appointment to 63 left-out candidates as special case by invoking Rule 19 of the rules of 2012. Stop. He has submitted based on this said order that it is apparent that till 2018, the appointments were made from the said panel.
To comply that order of the tribunal, your lordship has seen that, yes, to comply the order of the tribunal to give appointment to some ST candidate, because 257 ST and SC candidates were not given appointment due to non-availability. So in order to thereafter some ST candidates have approached saying that they are available. So yes, your lordship can find from that page 363. Whereas Sri Indubhushan Naik before the Bhuvans was requested to direct response to appoint him as well as similarly situated other ST candidate.
Mr. Kutia Land Council, appearing on behalf of the state, Kutia Land AGA, appearing AGA, refuting the contention, the last contention raised by Mr. Patel, that appointments were made from said panel up to 2018 as submitted, that the said order was issued in the light of an order passed by the Odisha Administrative Tribunal to fill up posts out of 257 posts which were reserved for SC,
my scheduled tribe, my lord.
SC,
SC and ST, but
the post office contains that all the 63 candidates were permitted to be appointed based on the panel were ST candidate.
Yes, ma'am. That page 363 reflects.
Stop. Next. We are not convinced with the submission advanced on behalf of the appellants that the state was under obligation to fill up all the vacancies existing prior to 31/3/2014 from the panel which was from the panel prepared by the state government for the said purpose. Stop. This is for two reasons. Stop. Firstly, only because of inclusion of the names of the appellants in the panel, they did not have any indefeasible right to be appointed against the vacancies which were existing. Stop. Secondly, it cannot be said based on the present set of facts that the state, without any valid reason, decided not to fill up the said 257 posts. There is some explanation which appears to be justifiable and has been tendered as to why those 257 posts could not be filled up. Stop. The appellants do not belong to ST category.
ST or SC?
ST or SC category. Stop. They could not claim their appointment against those 257 posts. Stop. In such view of the matter, in our considered opinion, the appellant, the decision rendered in case of Shankar Sandas does not favor their case at all. Where is Shankar's? Stop. It is noted that in case of Shankar Sandas, the Constitution bench, in no uncertain terms, has held that the state is under no legal duty to fill up all or any of the vacancies, but with an observation, vacancies. So stop. It, however, relevant portion of so and so in case of Shankar Sandas is noted, is quoted here in below. This one. दिखा दोगे? Stop. In case of, in the recent decision in case of Anurag Sharma, जो citation है ना change कर दोगे 2023 volume 3 SCC 77P. The Supreme Court, after having dealt with catena of decisions on the point, has concluded in paragraph 82 and 83 as under.
The last line of the 85, my lord, your lordship may say
As
85.2.
under.
85.2.
Oh, stop. To 85.
Yes.
The main thing is this. Yeah. In this case, by Virabhaya. So now the Supreme Court has held that vacancy which occurred prior to amended rules would be governed by the old rules and not by the amended rules. Says does not reflect the correct proposition of the submission made on behalf of the appellants finds direct answer in the Supreme Court's decision in case of Anurag Sarma bracketed Supra, wherein the Supreme Court unequivocally held that the law stated in YV Rangaiya versus J. Srinivas Rao, reported in 1983, 3 SCC 284, to the effect that the vacancies which occurred prior to the amended rules would be governed by the rules and not by the amended rules, comma, does not reflect the correct proposition of law governing the service under the Union and the states under Part 14 of the Constitution of India. Stop. The proposition of law laid down in case of YV Rangaiya has been specifically overruled by the Supreme Court in case of Anurag Sarma bracketed Supra. Stop. Next. Situated thus, comma, we do not find any legal infirmity in the judgment, impugned judgment rendered by the learned single judge requiring this court's interference in the present intra-court appeal. Stop. This appeal, one appeal or how many?
Two appeals there.
These appeals are accordingly dismissed. Yes. Thank you, Mr. Patel.
Only I appreciate the judgment.
I appreciate.
My contention was that after 186 to whatever remained vacancies from 2273, there should be a conscious decision of government not to fill up by the old rule. That is not there. That is lacking. That is why I relied in Ramalu and Shankar Sandas.
Yeah, we also उसके पहले लिखा we we are also of the view that the appellants cannot claim parity with those 63 candidates who were subsequently appointed from the panel, as those 63 were scheduled tribe candidates and who came to be appointed in the light of certain order passed by the Orissa Administrative Tribunal.
See, in
That is,
page,
I have,
page 363 of the read petition, that the case number is there.
and the
As per-
tribunal's order is also there. 360 onwards. There is slide.
Thank you so much, Mr. Patel.
Obliged.
You give us good assistance.
You patient sharing well. Yes.
Item number 35.
Lordship, on 1/5/2024, your Lordship has been pleased to issue notice on the question of limitation. However, a noting has been given that due to non-filing of the requisites, the notice could not be issued. I'll just verify with the office. My Lordship may grant me some time. If not filed, I'll. It must have been filed, but there is nothing on record available with me to. It's not there.
1 week further time is allowed for filing requisites for issuance of notice, comma, if the requisites have not already been filed. Will this matter 1 week? Yes.
Item 36.
Item 36, the notice had gone on IA for condonation of delay.
Yes.
I think
Someone is appearing.
We are appearing for respondent number 2, my lord.
Who is for 1?
no, one is the permanent Lok Adalat who has passed the order, impugn order.
So you have implemented Lok Adalat as
Well,
party.
That should not have been done with fairness.
And you have filed writ petition against the order of Lok Adalat.
No, it's a order of the permanent Lok Adalat was challenged in the writ petition. Writ petition got dismissed. So therefore, challenging the dismissal of the writ petition, writ appeal has been filed.
How can you challenge order of Lok Adalat?
Since the order passed by the Lok Adalat is not appealable, therefore, my lord, the writ petition was filed.
A wakalatnama has been filed on behalf of respondent number 2. First off, the office note stands answered accordingly. First off, let this matter for admission. Now it is for admission, no?
My lord, the condonation of delay application.
Condonation of delay, how much delay?
10 to 12 days. My lord.
We can condone. We are condoning the delay. The number so delay of 13 days. And condoned.
Item 37.
Obliged.
And item 37, 12 days delay, my lord. Notice was issued on the question of limitation, my lord, on 1st May 2024. 12 days delay.
12 days.
Yes,
Who
notice
is
has
for
been
the
issued.
others?
Notice has been issued, my lord, on 1st of May.
Someone is appearing.
Your Lordship, I am appearing for OPSC.
Yes, well, sir. Hello. Delay condoned. Undelivered note R1, R3, R5. See, who are they?
R3, my lords, I have instructions to appear for R3.
5 and 6.
My lord.
Who is 5? Who is 6?
5 and 5 is a my lord, college, my lord. 5 and 6 are colleges.
So who is representing?
Yes, my lord.
Who is representing?
The principal should represent, my lord.
All right, condoned.
Because the address is given, they only said that Vibhuti Kanungo College. So perhaps for that reason, notice could not be issued. Either he had to say that principal of the Vibhuti Kanungo. 5 and 6 is mentioned, your lordship. The cause title that he has.
Already we are condoning delay.
Yes, my lord, your lordship condone delay. If 6 is the government college, I can also take notice on behalf of that 6.
All right.
Well.
We condone. Yes, put up for admission.
Well,
8 weeks.
Item 39.
39. The judgment of the Honorable Single Judge sought to be challenged before this Honorable Court in the present appeal has already been set aside by the judgment passed by this Honorable Court on. This is the judgment, your lordship. The batch of case that junior teacher schematic. Here, there is a delay of only 16 days. But the judgment, common judgment was delivered by the Honorable Single Judge, and that judgment was challenged in some cases, and in other cases, those were filed with a 16 days delay.
Still, we will have to issue notice. Notice will go. We don't know what plea is taken.
16 days. There is a delay of 16 days.
Yes. Issue notice on the point of limitation.
Item 42.
Lord, here there is a delay of 94 days. The issue is the petitioner, while prosecuting her studies, her GNM course, she simultaneously got appointed through a walk-in interview as staff nurse. Then subsequently, on the basis of allegation made by some outsiders for the collector, an inquiry was conducted, and in inquiry, it was found that the petitioner remained for some period under unauthorized leave and parallelly prosecuting a regular course. While so
that is on where you are appearing.
I am appearing for the.
Come this side. Yes. So
the findings of the Honorable Court, my lord, that is the judgment passed by the Honorable Single Judge.
So we can condone the delay. The delay can be condoned. We'll hear you on merits.
94 days delay. Or in the limited delay condition, they have not actually any valid reason.
No. Valid reason there is the most valid reason is.
My humble submission before your lordship, they may be pay some costs to the advocates welfare fund.
94 days.
Not for 94.
94 days delay.
For more than 300 days, yes. 200 days, you can say. For more than 200 days, we will impose cost. I number so. Application is entitled for condonation of delay of 94 days in making this appeal. Stop. 95 days. Stop. Considering the explanation put forth in the application and in the interest of justice, we deem it proper to condone the delay. Stop. I number so is accordingly allowed. Delay is condoned.
This is for it.
Item 43.
Note 43. An affidavit has been filed on 25/6 in compliance to your lordship's order dated 59 dated 17/5/2024, my lord. It is regarding the congestion in the jails, my lord.
Yes. What have you done?
Almost, my lord, the goal has been achieved, my lord, almost.
Goal has been achieved.
Yes, yes, my lord. No, because we have transferred, from different
Yes,
jails.
yes, we don't dispute what you are saying.
The
Correct.
in 4 jails only, there are.
Please examine, Mr.
Yes, I've given a copy to my lord and friend. I think after we got the orders from the trial courts, the rest will be done. That is also we have indicated.
It is not there on record.
Record.
That's the affidavit is not there on record.
25th e-filing has been done. I have got the copies, my lord. If you, I have solved one copy, my lord and friend, the amicus
Yes, sir.
curiae. Yes, yes.
So we will take up on Monday.
Yes.
We can take it up on Monday. In the meanwhile, just see if that has been done, then
yes,
something good.
We're basically resorting to shifting from one place to the other. The other larger issue would be that the UTPs would be about 80%.
Yes.
Which your lordships have addressed in the previous orders. And the bails which have been granted, they are not able to avail it. That still remains at about 300 as of yesterday. Those issues, I'll make a short note for your lordship. People who have got bail, but they are not able to avail it because of lack of bail.
In fact, in every jail, there should be some audio system type of a thing, where all the prisoners may have the knowledge of their rights. Like every time when you can hear songs, you can hear music, and at the same some interval you can hear this notice also that those who are who have been granted bail or those who have not been granted bail who cannot pursue their cases, they may approach something of this kind should be there in every jail. No.
And another, my lord, another way.
In fact, in one of the jails in Bihar which I had visited, they had a system of radio system. So they had a radio station at one place, and from there they would make announcements, which all the prisoners could, and they could some tune songs or something. Public, yes. So it was a radio station. I had seen that. So something should be done so that the prisoners should come out with their grievances. That,
my lord, I find from this affidavit that we have got there are 17,649 inmates, out of which 14,205, that is almost 80%, are under trials. So convicts, my lord, may consider whether they can be separated, because once the conviction has taken place, they should enjoy a real, because here these are. Yes, my lord, that my lord, what I pray, my lord, in this case, my lord may also consider whether such thing is possible and it can be done.
You consider.
Yes, I will take.
But the final authority.
In fact, these directions are there in the
Prison manual
also
is
to
there.
segregate them.
Segregate.
Earlier directions in this PIL also are there.
Yes, yes.
So basically the ball is in his court.
Yes,
He can
yes,
get it
definitely, my
implemented
lord. I
now.
will definitely, my lord.
If you want us to issue order, we shall issue order.
My lord,
Even without issuing orders.
No. There's my lord, the
You're
good,
lying.
good intent of a
See,
court
this
is
a
never
public
to be.
interest litigation. You as a counsel
Yes, yes.
also may come up with some idea, irrespective of what instructions do you get from him.
My lord, now they have changed completely. Now the jail system in many countries, the economic offenders, they have been lodged in a particular area where they can operate their businesses. Otherwise, we're losing people. They're fleeing from this country. My lord, the economic effects are very dangerously high to the country.
Oh, they should be given more liberty.
No, they should be allowed to, because otherwise, to operate their business, which is they are fleeing from the country. So one of the measures.
Then release them. Don't
No,
file cases
release, my
against
lord, cannot be done.
Don't file cases against them. If your finance is getting disturbed because of
My lord,
their arrest,
it is happening
don't
many.
arrest.
One of the major.
If someone commits crime, also important.
No, that itself, my lord, that cannot be. Now the under trials are now the major problem in the jails.
These offenders are living lavishly, so even though there are cases, they are living in London, getting their children married in California, they are enjoying the liberty. What more liberty they want, I don't understand.
There is just.
And then if there are under trials, have you examined why the trials are not taking place?
That means, my lord.
Has the state addressed the issue?
That is it.
What is sanctioning that they should be syndicated? You advise.
So I am monitoring one of the trials. I'll do that. Which is that?
Each month, my lord, monitoring those trials of the political cases. 442 political cases.
The state is.
Yes.
See what I tell the judicial officers also, that the witnesses are to come to you. You cannot go to the witnesses.
Yes, that is, my lord.
So if the trial is getting, if the witnesses are turning up and they are not being examined by the court, then it's a different matter.
The prosecution
but
is.
If the witnesses are not coming, then what the courts can do?
Yes, that's correct. My lord, sir, monitoring those cases.
The judiciary is being is under pressure, is under criticism also to a great extent, that so many trials are pending. The trial courts cannot do anything.
No.
The trial courts have limited. They have a courtroom. They sit in the courtroom. They cannot go to bring a witness.
Yes.
We will see. Please see. It is stated by the council representing the state of Odisha that an affidavit has been filed on 25/6/2024 online. The said affidavit is not there on record. list this matter on Monday.
Item number 46.
Order of signatures, that is annexer 1. Because my challenge is the two grounds only. One is with regard to maintainability.
This is the page.
My lord, here, the work was awarded by Mahanadi Coalfields
My God, what
to the
page is
respondents
this?
for transportation of coal.
Oh.
Agreement was between Mahanadi Coalfields.
46?
Yes, sir. Yes.
Oh, there's not jail case. What is 45?
The judgments are.
So many writ petitions. Oh, God. So these are two individual writ petitions. Release karo. No, all writ petitions shall be dis. Yes, no. And now this WPCs can be released. Yes. WPCs. Yes, 46.
46. The input order annex 1. That is, recruitment page starts from page 20. Here I have challenged this order on two grounds. One is, first is with regard to maintenance of the
For
recruitment.
admission.
Yes, sir.
First,
Yes, what is the order of this court?
that is the annex of relevant page 20 minutes. There,
Page 20.
Yes, yes. Starts from the upper relevant portions, page 20. Start from page 18.
Yes.
May I read, Mr.
Yes.
Mr. Patnaik, Law Advocate, appearing on behalf of the petitioner, and submits his client is a transporter engaged under the contractor by Mahanadi Coalfields Limited. Impugn order is dated 3rd August 2015, made by the opposite party number 1, rejecting the clients and other transport.
So Mahanadi Coalfield Limited was not a party.
Was not a party. That was my objection. That was not. They have said that since chairman cum managing director is a party, it is not necessary to really. It's a technical objection. I have cited 2 judgments, my lordship. I have already there. He made a party. Yes. Company was, because agreement work was awarded by Mahanadi Coalfields. Agreement intercept Mahanadi Coalfields and the respondent. 2 judgments, my lordship. My lordship.
Is that paragraph 3?
Yes, sir. With regard to maintenance, I have 2 judgments I have already given. Further,
that railway matter.
yes.
The order was passed by general manager, relay. Because subsequent they have referred to some judgments and they have said that state should be the party. Subsequent 2014 judgment.
Yes. What is your submission?
My lord, no submission. My lord, my submission is twofold. First, my lord.
No, this is the main submission
Yes,
which is making.
my lord, regarding that maintainability that they were not, and that we have made the managing CMD the party, but not the man of the coalfields. They have not taken that stand in the counter affidavit. Secondly,
Who has not taken the stand?
the man of the coalfields.
Man of the coalfield is taking a stand in this appeal.
My lord.
They are
My lord,
aggrieved by this.
My lord will see, this is merely the CMD is represented by the man of the
So
coalfields.
you could have impleted Mahanadi through CMD or whatever.
My lord, we have
But you have
stated, my
impleted
lord, in our
CMD.
writ application. In the writ, my lord, the nomenclature is this.
Mr. Patnaik, they have raised that plea before the learned single judge.
They
That
didn't
has been
raise it, my lord,
Yes.
to a counter, my lord.
In the
They-
counter,
they-
my lord, see paragraph 7 of my counter, I have taken that. Writ is not maintainable against trade. Opposition 1 and 3. Specific objection. It is not maintainable against. Paragraph 7 of my counter at page 99. words.
My lord,
Specific
what I
objection.
submit
They have
is
not
this.
answered anything. They have not filed any rejoinder.
My lord, what we submit is this, that it is, my lord, merely a technical point, my lord. And secondly, it is, my
So
lord,
that point was technical before the Supreme Court also.
my lord, kindly see, my lord, I have, its chairman come managing director, Mahanadi Coalfields, my lord. Only it's a merely a technical point, my lord.
That was the the issue there also. The general manager was implemented as party
My lord,
in this case.
my lord. But here, my lord, the question is this, whatever they are saying, I submit that the only point is that their general manager was made a party. Mahanadi Coalfields was to be made a party, my lord. But my lord, I seek then I will make them a party.
No, we will demand.
The CMD, the head of the institution was made the party, my lord.
This is what the Supreme
CMD is the made a
Mr.
party.
Sahu, which paragraph? Which paragraph?
Paragraph 7 of my counter. Judgment mercy.
Writ petition is not maintainable against
Yes, sir,
opposition
that,
party 1 and 3.
That in our counter at page
7, paragraph 7.
page 99. my paragraph
It is not
Specific.
maintainable against the opposite party 1 and 3. And my lord, kindly see para 5, they say that the relief sought for in the present writ application is solely based on the breach of non-statutory concluded contract, intercept petitioner and man of the coalfields. Hence, the writ petition seeking enforcement of such rights and liability under the contract is not maintainable. The Honorable Court is not appropriate forum for resolution of such civil dispute, my lord.
The disputed question is a contract, disputed question of fact, that stand is always taken.
My lord, here the CMD is also representing, my lord, the man of the coalfield is the apex authority, my lord.
Judgment.
And secondly, and it is a pure public sector undertaking, my lord. Railway is a
Railways are what?
under the ministry, my lord. Here it is a public sector undertaking, and my lord, MCL is under the Coal India, my
So
lord.
therefore, the MCL is a body,
My
corporate.
my what
The
I
others are the officers under that company.
the CMD is the chairman, my lord. Sorry. This chairman come managing director, my lord, we have written. And for all these years, my lord, we are complaining that you are the composite lead distance is more and you are not paying us the dues.
And for that, that was an approval order. And all this year, my lord, if my lord will go strictly by the counter, it says that para 7th writ is not maintainable against opposite party 1 and 3.
Why are you referring to the counter affidavit? We are on the order.
My lord, the order says that order is, my lord, objection regarding omission to impugn Mahanadi Coalfield itself is a technical in nature. Impugned order was made by chairman cum managing director. It says that impugned order was made by the chairman cum managing director. If my lord will see the writ petition, page 31, it was made by chairman cum managing director Mahanadi Coalfields.
Impugned order is why set aside?
My lord?
Impugned order is set aside on what ground?
My lord, on the ground that there was a report filed by the report where it says that it is not to 5 to 6. Lead distance is not 5 to 6, but it is 6 to 7.
On merit or truth, that report was not accepted by the authority. Subsequently, there was a study conducted. Another report.
Where is the reasoning? There is no reason assigned.
My lord, kindly see page 1586 of the writ petition.
We are seeing the order.
My lord.
So why the order was interfered with?
My lord, the order was interfered because there was a conclusion done by their IED.
Mr. Where is the reason assigned in the order?
My lord, the reason assigned in the order is this one, my lord. I'll read it. Para 3. The report is clear on the composite lead being in range of 6 to 7 kilometers. My lord, this para 3, my lord will find in the conclusion that is derived by their own study. As for the study, the
sorry, we are not satisfied. The Mahanadi Coalfield Limited. What is it? Mahanadi Coalfield Limited,
Yes.
comma, subsidiary company of Coal India Limited has filed the present intra-court appeal questioning an order passed by a learned single judge of this court, which reads thus, Pura Court. And counsel appearing on behalf of the appellant has made twofold submissions. First off, he has submitted that in the writ petition, Mahanadi Coalfield Limited was not impleaded as a party, and in its place, Mahanadi party, which was required, and therefore the writ petition suffered from non-joinder of necessary party in the light of Supreme Court's decision in case of General Manager Northern Railway, Baroda House, New Delhi versus Ranjit Mal versus so and so. Bracketed. Reported in 1977, Volume 1, SCC 484. So he had further submitted that the single judge has set aside the order passed by whom?
Now that it is chairman or managing director, Mahanadi Coalfields Limited.
That order annexed to one of the
writ petition, page 30.
order passed by CMD that was under challenge.
Passed by the chairman from Managing Director, MCF Limited.
MCL.
MCL. But the impugned judgment does not disclose the reason for setting aside the order. So stop. He has also argued that it was a contract matter.
Yes, yes.
Where is the contract?
It was sponsored agreement membership annexer 4. Annexer. There's the ex-servicemen agencies. Appointed to an they have been sponsored, work was awarded, there was a specific agreement annexer 4. That is the interest of monarchical bids and the country.
Very good. That the dispute arose out of a contract agreement. And
annexer 4 page starts with page 40. 41 is the relevant part. Page 41.
Contract agreement. Most of in such view of the matter, land court, land single judge ought not to have entered into dispute arising out of a contract, arising out of a contract in the nature of contract of engagement for mechanical transfer / transport of coal, etc. Stop. Next. After having perused the impugned order passed by the land single judge, we find force in submission advanced on behalf of the appellant that it does not reflect the clear reason why the order passed by the CMD required interference. So stop. Further, in the counter affidavit, you have taken this plea that writ petition should not be entertained because it arose out of a contract.
Yes.
Oh, yes. Paragraph 5.
We also find force in the submission that the counter affidavit filed on behalf of the appellant was not considered. So stop. Considering the facts and circumstances, the impugned order so is hereby set aside. The writ sub WPC so and so is directed to be restored to its original file. Let WPC so and so be placed before assigned bench.
The connected matter.
Similar. One connected matter is there. Similar, same.
Item 47.
Item 47 may I play for tomorrow.
47 tomorrow.
Well, I have requested him.
Tomorrow.
Item number 48.
From 48, pursuant to lordship direction, I have filed a conditional affidavit with cost to your lordship. I filed it on Monday, it's on 24. I think it has not come your lordship court because as per the noting, shows that not affidavit not filed, but I have filed
It has
on
been
24th.
stated
24th I have filed. Cost also deposited. Copy already sought.
It has been stated by learned counsel representing
For OP number 3 and 7.
OP number 3 and 7 that an affidavit has been filed bringing on record the relevant transactions
Yes.
in,
Specific query your lordship wrote there is that
in
pursuant to-
compliance of this court's order dated
19.
15/3/2023.
Yes.
15/3/2022 and previous order dated last order was
15/3 and last.
19 June matters.
19/6 when he was asked to pay.
22.
2012.
19/6.
19 is the last.
Yes, that one.
19/6/2024. 24 after depositing the amount of cost as directed.
There's no page 34. Index it. Scan anyway. Probably they've given it, but not scanned.
Yes, what is it? No, which she has recently filed. It's not there.
It has not been scanned. Might be there on the record, but not scanned. We have the page. Regional affidavit we have. Thereafter we don't show. And I is there.
So what is there? Let us see. You have filed only one copy.
Yes, my lordship.
You have filed only one copy or two copies?
2 copies I have filed. I have instructed my issue.
It's Achi. Vijay, Achi,
It is
no,
34.
it has not been indexed. It is there.
It is there.
It is there.
Oh.
You're right. Additional counter activity is there. Running page 62.
62.
62 running page. Here it goes 62. 62 is the last page. It starts at 34. 34, sorry, starts at 59. You are Mr. Mahapatra?
Yes, madam.
So what transactions were you apprehensive or apprehensive?
There was an apprehension that there may be.
There may be.
Yes, my lords. So that's why this order was
That's why you
passed.
wanted details of the transactions.
Yes, ma'am.
Paragraph 10 and 11, if you lordship see paragraph 10 of my affidavit. 11 also I have explained existing policy, we are dispose of some.
So there is nothing.
No, madam, this was the order passed on 15th March. They didn't comply. That was my submission. Pleadings are almost over.
So what do you need now?
A date may be fixed, my lord, for final
Oh,
hearing of
the
the.
ordinance, Mr. Counsel, the ordinance has lost its life.
Yes, my lords.
So there is no purpose pursuing the matter anymore.
There are no transactions. Your worry was
There is no-
transactions.
There is no transaction.
Now that's become law.
Which law?
The section 16(2).
16(2), where is that?
Pursuant to the ordinance passed,
Annexure A.
16(2) is amended, annexure A, madam.
Yes, it has been enacted.
Yes, that is incorporated.
So that is involved. What is wrong in that?
Well,
That ordinance.
but that was a challenge actually.
All right. So what is wrong? What is the illegality?
Our submission was that it takes away the power of the government in dealing with alienation of temple property.
There, see, whether the legislature lacked legislative competence.
No.
Then how is the provision unreasonable? Does it violate any provision of the Constitution?
My lord, my challenge was this amendment violates the very purpose of passing the Sri Jagannath Temple Act. So a final date may be fixed, I'll argue the matter.
How? How does it violate? Because then government themselves say that no, we have a supervisory power. We will look into that. Look at the
can you see
counter
the
affidavit of the
amended-
government. Counter affidavit of the government.
Yes,
Have you seen that?
this one, madam.
Filed earlier.
Yes, I have seen that.
What do they say?
They have given the reason for amendment.
And
I am saying they don't have power to amend that particular provision because it takes away power of the committee. The government.
Can take away power of the government.
That is not permissible under this act. That was
Only
under
let
challenge.
us see the act. Matters are unnecessarily pending.
My lord, 3 weeks time may be given.
No, 3 weeks.
because you were in a hurry, we asked them to pay cost and give the affidavit. Now you are saying 3 weeks.
My lord, that was not complied with. My submission was that the first order is not complied
That
with.
is why there was urgency. That is why.
Because it's been already 2
We
years.
were also under the impression that some transaction has taken place in the light of the ordinance. You did not care to examine that. In the meanwhile, the ordinance has turned into an act.
No, I know that.
Then?
But my lords, the order was that all the transactions they have
So why
entered
did
into,
you tell that on the last day?
they didn't
Till the
comply.
last hearing, we were under the impression that an ordinance was passed, that the life of the ordinance was 6 months, and in the meanwhile, they did certain transactions and allowed the ordinance to lapse.
That was not.
This is the impression which you gave.
No, when we asked them to give details of transactions, as the council who has filed the PIL, you should have been aware if there is some transaction. We thought you are worried because of that. That is why we asked them.
My prayer is not to give the list of transactions. This was the order passed by the court, actually, honorable court.
Oh, you would have asked for recall of the order. That was not your interest. Okay. Then no problem. They can take whatever transactions they want. If that is not your anxiety. Isn't your submission contradictory, self-contradictory? First you say this amendment has been done by way of ordinance, which takes away powers of the government. So illegal transactions may be done.
Yes, madam.
Okay. But no transactions have been done. So you are saying that I was not, that is not my intention.
Madam, this was passed in.
It should be your intention, whether transactions have been done or not.
Yes, my lord.
Yes.
I'm apprehending that they may be misused
You are
that power.
apprehending, but 3 years have passed, you have taken no instructions, no information is there with you. Only an apprehension since 3 years.
That was the order, my lord.
No, that was the order then, because court was also anxious. But by this time, you should have known that there is no transaction.
There are transactions. They have filed like annexure.
So as per that.
Not on the, as per the regulation.
The affidavit, you are not questioning the affidavit.
I'm not questioning the affidavit.
No, it's for the state. This is it. Here it's seen as otherwise especially provided in this head. Publication of file is based on
Previous sanction.
more than 5 years. What they have done is save as
Previous sanction has gone.
no, nothing. Well, property taken possession of recovered may be leased out sold or subject to such conditions as in size may be prescribed by whom? As may be prescribed.
Wait.
Someone will have to address. Who is for the estate?
Yeah.
See, the difference between the earlier provision and the present provision is that in the earlier provision, there was this thing,
Previous sanction of the state.
previous sanction of the estate government was required before dealing with any immovable property. But now it says, save as otherwise provided, the immovable property taken possession by the committee may be leased out, sold, or otherwise alienated by it, subject to such conditions and exceptions, and in such manner as may be prescribed by whom?
By the committee.
Where is that?
That is not there in the section. It can be prescribed by the person who is buying also, it can be prescribed.
No, I think it's
Look at that
committee.
section. No, that is not there. Prescribed in the act, prescribed by whom?
That has a given law.
It is not clear.
That I will have to examine now.
Objects.
Which page is
Objects
that?
and reasons, if it is there
Which
also,
page?
it was.
Just.
Section. 170. 184.
At the committee. Right.
APF regulation.
Plus, I will clarify that plus by one affidavit, whether it should be by the committee or any rule to be framed pursuant to this amendment law. That I will clarify by one
Affidavit will not do. You will, this is an act.
No.
You cannot change anything.
No,
We have to interpret whether it is intravirus or ultravirus.
Right.
Or if there is any other provision guiding that so that.
Right, but that just look like.
As jointly requested on behalf of the parties. This is matter on 2 weeks.
Yes, sir.
Huh? Yeah, what was that?
No, idea about ধরবে last minute ধরবে পরে দেখতে হবে টাইম হবে।
Like that, this is matter of 2 weeks.
Item 49.
My lord, in the 49, your lordship said there is a IA 2053/23.
No, you are in which case? WA 802.
802, my lord.
Yes, you are appealing for whom?
My appellant. State.
Yes.
Lordship said there is an IA 2053/2023.
2050.
53 miles.
53. This is about what?
That is regarding dispensing of the
certified copy.
Well, in the meantime, that certified copy has been filed.
Infructuous.
That has become infructuous.
2053 of 2023 has become infructuous as certified copy of the impugned order has been filed. Stop. This application stands disposed of accordingly. Yes.
This has come for hearing, my lord. Takes some time. You'll also fix it to next week any day.
What is this about?
This is regarding the selection of music teachers. That in terms of the advertisement, we have conducted the selection test. So that Honorable Single Judge has said that at the selection has not been conducted in terms of the advertisement directed for recruitment of music teachers. It will take some time. You may fix any day next week.
Sir, actually, the only problem is there is 7 to 8 persons who are actually musical teachers. So there is, since the last 4 years, that post has not been filled up. They have qualified themselves. The challenge about the technical part, the way the assessment has been made, so far as the marks are concerned, and the interview that is to be conducted, that was the subject matter of challenge. The Honorable Single Judge actually found out the modality as per the statute, their own advertisement, and held that, no, this has to be done like this. You publish the result accordingly. So that was the direction was given. There was some omission in the order for which a review application was filed in the meantime. After they filed the appeal, the review has also been allowed by modifying the order. I don't know, they have not challenged that order before the Lordship.
The review had the clerical mistake in that order. They have filed that some clerical mistake in that order.
No, it's not clerical, sir. It is one of the items who has been omitted for which mark has been awarded. So it's not a clerical mistake. I've got the order of the Honorable Single Judge after the review.
Please examine.
They have
Yes,
filed.
I'll examine.
And sir, the question is here, there is no stay, nothing is there. This should be appointed. State is suffering, in fact.
No, they have not qualified as per our grounds.
The Honorable Single Judge has said we are qualified and everything has been done.
No, but the employer is saying, we will see.
And sorry, the institutions where actually they have to be deployed, appointed as such, they are suffering.
Maybe.
We are sort of music teacher merit.
You are for whom?
I am for those
My lord,
suffering
may I pray, my lord,
applicants.
you'll also may fix it to Monday at 2 p.m. It can be disposed of.
2 p.m. Monday, not 2 p.m.
There is no slot.
Monday we are pressing it on Monday, we will hear.
2 p.m. we have fixed the.
Exactly.
All right, we will take up the matter on Monday. 2 p.m. is not the only time when the matters
Yes,
are
ma'am.
taken up.
Yes,
Before 2 p.m.
sorry,
take up matters.
sorry.
All right,
Well.
on Monday. As jointly requested, let's this matter on Monday. On Monday, you can make a mention if your case is now not likely to be taken up.
Right.
We can take up.
My lord.
Item number 50.
He should examine actually whether a fresh appeal is to be filed or not with regard to that review that has been made.
Please examine.
Yes, sir.
Item 50.
Item 50 also state appeal. No one is appearing on behalf of. Someone has appeared in this case.
Just
Siddheswar Malik.
Mr. Siddheswar Malik.
Yes.
He was here, in fact, waiting for this case. Maybe being called, someone got, he might have left because he was sitting.
This is regarding what?
This is regarding the recovery of RACP.
What is the point?
The point will they are not entitled to a particular grade pay. They have been allowed wrongly. Subsequently,
All
that
right,
was
we will take up to what? There is no representation on behalf of the respondent. Let's this matter tomorrow.
Item 51.
51, your lordships. The, the impugn order is at page 18. If your lordships will permit, in brief, I'll explain your lordships.
Please.
Your lordship, this was regarding a particular examination which these teachers were allowed to appear, especially if you as an improvement. And so he did appear, but when the results came out, there was a noting in the result as NC. That is not certified because there was they conceived that probably he does not have 45% in his +2 exams. So I went to the court and the court gave a direction that you reconsider the whole thing. And that result was published in the year 2020. So the authorities rectified it and issued a fresh certificate. But they gave the date to this certificate as if I have passed in the year 2022. So that's why I again came to the writ court. But the writ court found that no, because you had come earlier, so this is res judicata. That's the finding of the writ court on the...
You had come earlier, huh?
Earlier, I had come before the first certificate where there was an NC observation. And if I take your lordships to that certificate, lordships will find that certificate at page 22. Bottom, NC is written and NC meaning is also given. Not certified due to not fulfilling the eligibility criteria 45% marks in class +2. And your lordships, thereafter, I did approach the court. That order is at page 25.
Just one clarification, that 45 marks eligibility criteria, fulfill it at that stage or subsequently?
Yes. Fulfilled, and that's why they also rectified it.
So it was their mistake.
They rectified it.
That was rectified in 2022.
22.
The mistake was committed in 2020. That was rectified in 2022. According to you, your results should be treated to have been declared in 2020 itself.
Yes. Otherwise, my
Rectified
seniority.
result.
Yes. Otherwise, my seniority in my service is being affected.
Where is your class 12 results?
No, because if you make it 22, then this 2 years gap makes me lose my seniority in my service cadre. That's why I'm insisting that you take it
And
to
whether
20.
affidavit was filed in this case?
Counter affidavit was filed. The counter has been filed in this.
Counter has been filed by OP number 5. And there they have only stated that after receiving the copy of the certificate of 2022, this service of the petitioner has been regularized. But so far as the issue with respect to antedation of the certificate, date of issuance of the certificate, that the OP number 3 has to reply, my lord. The OP number 3 notice has been issued, but it has not been made sufficient.
No,
That is
sufficient. Sufficient.
Who is OP number?
Noting is it has been served. Postal tracking report.
My lord, so far as
The authority
like
issued
is
the
concerned, my lord, central government council is appearing, and though the loading has been stated that not been served.
You are also central government?
Yes. That I only take that.
So you are there for OP3?
OP3, 3 and.
So who had conducted the examination?
OP number.
OP number 2.
Who is OP number 2?
My lord.
Same body under OP number 3 only.
What is the name?
Regional Director, Regional Center, National Institute of Open Schoolings, NIOS, Bhubaneswar campus.
So they had conducted.
Yes, and the OP number 3 is Chairman of NIOS.
So NIOA had conducted the examination. Who is representing NIOA?
My lord,
You are representing NIOA.
yes, my lord.
So that result of 2022, there was some defect.
Yes, ma'am. That's my lord.
There was some defect. Whether that defect was attributable to the appellant or not.
But I may pray Lordship may kindly day after tomorrow because due to notice has been issued, they have not served to copy to the Union of India. You Lordship may call it day after tomorrow or Monday. I will take instruction.
Serve a copy. We'll take up on Monday.
Monday, madam.
We'll serve an extra copy.
Monday, madam.
Get an extra copy of the written appeal. And the writ petition also you serve.
The whole, we have annexed everything.
Be served on
Read-
council
copy of the
representing OP number 3.
Written annex.
This case on Monday.
Why there two result sheets of 2019, 120 and 21?
20.
One is of April 2019, one is of October 2019.
October 2020.
Look at page 20 and 21.
20 is October 2019.
Yes.
That was there when they issued the certificates. So by the time January 2020, my +2 result was there with 45% mark. They've accepted that. That's why they've rectified it.
No, that means you appeared twice.
Yes, I did a supplementary thing.
Yes.
But then that was not the issue for them. All
By
that
the
was
time you had passed.
Yes.
There
So
is
by
a
the time
scheme
I
can
applied for
improve
this,
their mark percentage mark if they have to not.
yes. So by the time January 2020, they had this. And that's why they rectified it. But there is no reason to take it 2 years forward. That's all the issue. But the single bench did not analyze that and thought it's res judicata. And
When they issued the certificate, it was 22. So that is why they've taken it as 22.
yes, but then it was their mistake. Yes.
No, but this 22 certificate, they must have in this 2022 certificate mentioned that you passed in such and such 2020 to 20.
2019. Where is that?
They have given that.
Where is that certificate?
Opino 5, counter of Opino 5.
Annexure A by what?
A by 5.
A by 5. They've given the examination session also. No. See, no, but
Examination held on 2007.
This is some new thing in Hindi.
the examination in the first annex 3, the examination month and year is given, January 2020.
So examination month is given. How can you be denied of your which page is this?
Annex 3, page 22. There the examination month year was given.
No, here they are saying session 2017-19. So it is prior.
No, that exam.
Which is the rectified?
The rectified one is at
Hindi one.
No.
Not that. Diploma in elementary education, not that.
Which page?
No. No. Here. It's here.
Hindi one. Annexure A by 5.
No, A by 5 is not under challenge.
No, not under challenge. Where is the rectified certificate?
No. I'll just show. I just showed it and then.
Find out, problem sometimes you can't see two screens together. Four, but two at simultaneously.
Additional affidavit. This is an additional affidavit, page number 4. There is an additional affidavit at flag A.
Yeah, it is that one.
Your Lordship will just look at page 4.
Page 4.
Yes, that's the mark sheet.
But it is that Hindi certificate only.
No, that's in English.
No, the subsequent one is English.
It's also Hindi and English both.
Yes, that is the pass certificate. This is the mark sheet.
If your Lordship will see, the NC which was there in the earlier certificate, that is absent here.
On the top, on the top, it is written 2017-19.
17-19.
But exams, is it written which exams? Year.
2017-19.
They're on top. That
On
is-
the top,
That is the course, but when examinations. There also, the date of issue is there. So whoever they gave it to, they don't have a choice unless it is clarified which examination.
come to. This page. Share 5A.
5?
A,
A5, A by 5, that's the same thing.
27.
Page 27.
If 5. 5, share 5 of it.
Sorry, the big, sorry.
The appeal 5.
5A.
5, not 5A, 5.
Sorry, yeah.
May I clarify your lordship? That exam also, there was a supplementary exam.
Page
So that is why it's January 2020.
27, it is
Okay,
27 of the data appeal.
Yes, annexure 5. Sorry, it is 5. 5 copy, so I was thinking of 5A.
Your lordships, that confusion between 17, 19 and 20 is because after the 17, 19, I did appear for a supplementary exam. So that is why my supplementary exam was January 2020. That showed NC. And so therefore, for all purposes, all my exams, all my date of appearances were over by January 2020. Only thing which was left was deletion of NC. So therefore, the new certificate should only have related back to January 2020.
So you have to just clarify share 5. You clarify yes. How do you say that 22 is the date of publication of result?
My lord.
That's what they say.
That is the date of the certificate. But only you understood the problem.
Yes, yes, ma'am.
Yes.
As requested by learned counsel representing respond number 3.
Yes, my lord.
Respond number 3. For seeking instructions, list this matter on
2 and 3, my lord.
2 and 3. List this matter on 2 weeks. Seek instructions.
All the affidavit that may be served.
That will be served to you. Let
Everything
requisite
will
number of copies of the writ appeal be served on learned counsel for the OP learned counsel for respond number 2 and 3 in course of the day. By today, you'll give him?
By tomorrow
By
morning.
tomorrow. Yes.
Item 53.
And the counter filed by the OP number 6 by state also, sir.
So initially, when you had come, your representation was directed to be disposed of.
Yes.
Thereafter, they issued.
They issued the fresh one, deleting that NC.
But that problem was, then subsequently the writ petition, they said
That is residual data.
New problem was, now they made it 22. And there when I came, the court said it's res judicata. Whereas the cause of action had really not arisen in the first 10 years.
Item 53, beg your pardon, my lord. This matter may be adjourned for tomorrow. The matter may be argued by my senior, Mr. Dolai.
Mr.
SK Dolai.
As requested. On behalf of the applicant tomorrow.
Cancel.
Item 54.
May I please your lordship? Lordship, I am appearing. Lordship, I may be permitted to withdraw this writ application with liberty to approach before.
Yes.
Lordship, I may be permitted.
Item 55.
Much obliged.
Your humble submission and repenting for Utkal University in the item number 55.
55, the university.
You are for the university?
Yes, sir. That will be for university.
Yes.
Minutes. May it please minutes. 55. The petitioner challenges minute the rejection order of minutes grant of recognition. That the rejection order is minutes at
What
page
should we raise, Mr. Paul?
minutes.
It's already 4:30. Come on. Matters for 1 week. Yeah.
Recognition may be adjourned.
Three matters. We'll take up your matter also after a week.
Great.
1 week.
Item 60 can you taken up tomorrow?
Item number 57.
60 tomorrow.
60.
Mine.
60
Mine.
tomorrow.
57.
57, my lord, notice has been issued. I think, my lord, respondent one has appeared some months. Not present.
1 week. No one appears on behalf of the respondent.
My lord, item number 57, I'm appearing for opposite party 3.
Yes. So what do you want?
My appearance may be noted.
Have you filed wakalatnama?
Yes, my lord.
When?
On 19th,
All right. What is your name?
Jeannie Mohanty.
Yes, the name appears actually. Yes. Nice.
Yes, jointly request to list this matter on 1 week.
She mentioned.